So Dandridge was number 4?
And that's number 1?
Well, no, it's probably number 2. Melnick is gonna be stuck in this other trial. He's got number 1 with Richardson. And then number 2, can't remember what judge, it's Dunaway. Yesterday, Kamani King filed an entry of appearance to represent the guy. It had been Mr. Apt forever and ever, and Kamani filed an entry yesterday. So I sent him an email, Apt sent me an email, it's like, hey, I'm not on the case. I think he sent it to everyone. I wrote him back, thanks. Then I sent one to Mr. King saying, this is an active trial calendar. Dunaway has to excuse you, otherwise you're on. And he apparently there's a co-defendant. There may have been information that Dunaway's team didn't get to us, but I wouldn't be surprised if that one went away as well. And there's just one case ahead, Jackson, and I think that is a line ADA case, meaning not a murder or a rape or something. And so it was probably put on there by that judge just to apply enough pressure to make it go away.
Right.
So
Got it.
saddle up,
Thank you.
but you'll be kept posted.
Okay.
Is there going to be any evidence, Ms. Reimer, of a statement from Mr. Williams?
No.
Ms. Niles is putting together the jury charge. We don't need any charges about a defendant's statement.
No, there is no statement.
Okay. You didn't include in what you submitted anything about the statute of limitations or needing to prove, because we didn't see it. But I'm having Ms. Niles look for some pattern language. If you're aware of non-pattern language that addresses that, you could get someone to send that to Ms. Nelson.
Sure. That was the one I had previously put together back in January, and I apparently did not file that. I just sent it to Miss Wood.
Okay,
So I apologize.
that's all right.
Yes. Oh, are you, is it me, right? No. Okay. No, it's fine. That'll be just that. In his car, it definitely would have been.
Did you see Kimberly was here?
Didn't you there?
So she's here. She's in the city. But when she asked her, did they? Because she said he's in here now. So I asked her, she said, no, I just met her. She said, had I known her testimony was yesterday, I would have been here to support her. I said, yeah. I said, you couldn't say it. Yeah. Are you looking for?
Yeah.
Got it? Oh, okay. So I was about to just pull it from Cleo if we want. Or one of those cases. Do you have a copy, another copy?
Yes.
Do you need it?
Yeah. Is that?
She said, I didn't.
Camera.
Yeah. Knew the outcome. And so she. It was. You know, I have video. So I think you were my answer.
Your Honor, for the pattern and variant instructions, for such limitations, it's 150:10 and 150:11 for the tolling language.
Okay, and 150:12.
Yes.
All right, that's what Ms. Niles found, so no reason not to use that. That's what you were gonna submit? Okay, thanks.
And I apologize for my lapse in including it.
Sorry. Okay. Ms. Wood, do you all need to be chatting with Mr. Williams right now, or everyone's in a good space?
That's fine.
Good.
And he did well. Okay. No, they're not. They're gonna get that picture and that boy's gonna be pretty.
No, that's true.
I think so. Debbie Gordon just, oh, you're telling me he did. Okay, thank you. He got it.
I knew that was.
Pardon?
I see everybody starting to scan.
Right, then he'd show up, exactly. Everyone's gone. When Ms. Rivers comes back out, we'll get Ms. Wood out, get rolling.
Gotcha.
I think they fixed the restaurant,
Good. I bumped into the plumber guy when I was leaving last night. You were in 4A. And he said they kind of got it working. He was carrying a bucket of water in there. I don't know what that was all about, but he said he thinks they're gonna have to replace both. He said one of them is just, it's kind of fixed, but it just, they're going to put in a whole new one. And he said they're the same age, so they'll probably replace both. If you get word that one or both is not working, if you can show them where the restrooms are by the elevator, they can use those.
Okay.
Okay, and if you get Ms. Wood.
Oh, yes, could you forward the twos? The.
All right, Ms. Rivers, are you ready?
Right.
Let's get on the record, please, in State versus Williams. It is Tuesday morning. We're running a little late because we had a juror get in late, but he is now here. We've got all 14. Ms. Robinson, before we bring the jurors in, anything from state?
Yes, Your Honor. Yes, we do have one housekeeping matter to address. And I'll let Ms. Reimer address it.
Scheduling?
Yeah, scheduling.
Your Honor, due to some flight issues and some sicknesses and scheduling issues, the state anticipates being through witnesses today by like 1 o'clock lunchtime.
Okay, let's be more specific. I know there was this ominous forecast from Ms. Robinson that, hey, someone's going to be flying in, and I mean, it was clear skies last night. What's the flight situation?
The flight is set to arrive tomorrow.
Someone missed their flight?
There was booking issues.
Booking issues.
Yes, Your Honor.
Okay, who's that?
Alan Bradford Dixon, he is the DNA analyst for the 413 case,
Where's he coming from?
Oregon.
Okay. Oh, we met him on screen before.
Yes,
I
sure.
remember. Okay. All right. And he'll be here when tomorrow?
The morning of his flight arrives, but he'll be here for the afternoon.
Okay. So that's one witness who wouldn't take very long, but you were gonna fill all day. So what else has changed?
The Miss Fowler, she is ill. We could get her here today, but she is ill. She was ill yesterday. That's why we called out of order yesterday.
What does she, I know she's GBI, but what's the out of order part with her?
She's the CODIS match.
Okay.
So she's integral as well, but she would have been after Miss Carroll instead of
Instead of Schmidt?
Yes.
Okay.
But she's for both cases, both victims.
Okay.
And then the Miss Whitmore's schedule is, from our understanding.
I mean, it's really our preference to that she be the last witness.
Right. I also, go ahead.
No, I heard your preference is to have her be the last witness, but my preference is to not stop at lunch today.
Right.
We still have Ms. Jones, I assume.
Yes, she's the first witness this morning, followed
Okay,
by Officer Weatherholt.
okay. And then that's where we would stop today, or there are more people?
There is Officer Natasha Wilkins today as well.
Okay, and she's connected to the Jones set of facts?
Yes, today is all of Miss Jones' facts.
All right, you didn't find an East Point detective who did actual work on the Herring side of the case? No, okay. Just checking, because there were other East Point names on here. Okay. Is Ms. Whitmore not available this afternoon, or it is your flow preference to have her come at the end?
It's flow preference for her to come at the end due to the nature of her testimony, so as not to confuse the jurors more or at all. And also, we have been unable to nail down her schedule for today.
Okay. So today is for sure Ms. Jones and Weatherholt and Wilkins. and then you had hoped to have Fowler and Dixon as well.
Yes.
You explain why those two can't be here. And then is Ms. Whitmore the only other witness, or are there other witnesses?
We have the investigator for the office, but again, that wraps everything up after that testimony, because it's the investigation.
Okay, is that John or Albia?
John.
Okay. And I'm confident you can get him here whenever you want. But that's who you sort of see as the final witness. Okay, my request then is that you have folks figure out if Ms. Whitmore can be here this afternoon.
Yes.
If we need to have a longer lunch break because she can't be here till 2 or something, we'll do that. But as long as she's testifying after Ms. Jones and Ms. Herring, I'm not understanding what the confusion would be. I understand why you might want her to be one of the last witnesses, but just because of events beyond your control with Mr. Dixon and Ms. Fowler, I'll want us to use as much of this afternoon as we can. So if people can figure out Ms. Whitmore's availability this afternoon, that would be great.
Yeah, just together.
All right. Anything else?
Yes, I spoke to defense this morning. The sexual assault kit, I went to this on the record in front of Mr. Williams as well. The sexual assault kit for Miss Jones is from 2006, so it is old. The adhesive on her sticker was attached yesterday, but in transport it came off. I still have it. I did not want to affix it to the kit without it being on the record in front of everybody.
It's a sticker that had been on there before, but this is so old, it came off.
It was literally on there last night before when we transported it back to the office, and transport this morning it came off.
It fell off.
Yes, I can
Okay.
approach with it if you would like to see it.
If Ms. Wood or Ms. Feely have seen it and they're not concerned with you reaffixing it, as long as, I don't know how you're gonna have a witness explain it. If it's like, I wouldn't have put Scotch tape on here, or how are you reaffixing it?
I could have investigator John affix the via Scotch tape, and then I can have him testify to that.
Ms. Wood or Ms. Feely, how do you want us to navigate it? We could put the sticker in a separate envelope and have that be exhibit, I don't know what exhibit this is.
27.
27, so 27A could be an envelope that has the sticker in it, so it's not being put back on there. And then someone can testify to it came off. What I don't want to do is artificially create a scenario where the jurors are wondering, like, was this also improperly sealed? And it may well have been, but that's not one of those scenarios. So I just want it to be as smooth as possible. Do you have a preference?
I think that you're on the paper.
Okay, so I'll get you, unless you have an envelope, before the jurors come in, I'll get you an envelope, and that can be 27A, and that can be the sticker that came off. And then what Investigator John can talk about the
Yeah,
sticker
I
coming
can,
off?
I can step out, I can have him put it in the envelope too. Yeah, because he was there when we pulled it out this morning and saw
Okay,
it.
and everyone said, ah, the sticker came off. All right, Ms. Feely, anything you want to get on the record concerning 27 and the lost, it's not lost, the detached sticker?
Yeah.
Okay. And I should have made clear when we started the proceedings this morning, Mr. Williams is here in court with his lawyers. And we've got both our prosecutors here. All right, anything else from the state?
Hang on.
Okay. Ms. Wood, anything from the defense?
No.
All right, I'm gonna go get an envelope. When I come back out, we can bring the jurors out.
Judges want to bring your envelope out?
Yeah, so just the numbers for out.
Oh, you want
Yes, we just addressed that.
to. So,
Yes, what we're doing is putting it as 27 S.
I think Whitmore is gonna be unavailable this afternoon, because she has school.
Right, put it out this morning. Right, we will put it in an envelope labeled 27.
It's at around at 10 for them.
And
That's what we're trying to figure out.
Do you just want me to put a state exhibit on it or no?
However you want to.
Okay.
Still there.
You see on it. Okay. We'll never have it here, so Sean. Did you? Yeah.
Thank you so much.
Thank you, Kevin.
Hi. Just like it's for any of them.
Okay.
Yeah, it's all about.
Sounds good. Did you need, Eric?
What's next name, John?
No, Jones is up and his
Mhm.
hair is up. She's home.
Okay.
Right, if you see me, Johnson, I'm sure you do shit.
All right, Ms. Reimer, ready for the jury?
Yes, sure.
Ms. Wood, let's bring him in. So it sounds like you all will finish Wednesday afternoon.
Yes.
Okay.
Okay, so.
Is there any reason to be concerned that Ms. Fowler won't be able to come tomorrow, or she's just gonna have to?
All right, jury.
She should be.
I'll do the president of the county board.
Thank you, Deputy Gordon. Everyone else can be seated. Happy Tuesday, everyone. Good to see you all back here. I forgot to mention a longstanding rule in the courthouse that any juror who's more than 15 minutes late brings donuts for the jury the next day. Just saying. And the judge. No, I appreciate everyone doing their best to get here. I remarked on my way in that the city has figured out a way to block yet another lane right around the courthouse. For whatever reason, they're constricting and restricting traffic around the courthouse, which just means it gets congested further and further away. I bumped into a plumber guy last night after you guys had left, and he said both the restrooms should be working. Don't know if that's the case, but if one breaks down, let Deputy Gordon know. There are restrooms by the elevators, non-public access elevators down the hallway a little bit, and there are restrooms there, male and female. So there is more space for you to use should you need it. But he'll show you, Deputy Gordon will show you if those break. Please, during one of your breaks today, lunchtime, whenever, talk amongst yourselves to see if everyone can stay until 6 tomorrow night. That was the possible plan because we won't be starting till 1. However, in talking with the lawyers during the bonus time we had this morning, I've learned that we're ahead of schedule. Yesterday was very productive, and the state may well rest tomorrow at some point in that 1 to 5 or 6 window. So ideally, you'll give the green light to stay as late as 6 if we need to, but we might end a little early tomorrow, and we'll probably end a little early today. There are a couple of witnesses who cannot be here today, had hoped to be, but they'll be here tomorrow. But even with that switching around, the state's forecast, and it's just a forecast, is that they'll be resting at some point in tomorrow afternoon's session. So with that, we remain in the midst of the state's presentation. I will ask Ms. Reimer to call the state's next witness.
The state calls Ms. Lucenda Jones.
Face me and raise your right hand. You swear or affirm that testimony you will give is the truth, the only truth, and that's what peace of God. Good Lord, and have a seat. Can you say the spelling name and record?
Lucenda Jones, Lucinda Jones.
Good morning, Ms. Jones. How are you doing?
Good.
What is your current age?
I'm 43.
And how old were you in October of 2006?
25.
And can you tell us a little bit what your life was like back in 2006?
I was trying to get my life together because I was smoking crack. And I remember coming from this treatment facility called Mary Hall Freedom House.
Okay.
I was going to visit my brother because he had my kids. They had denied my pass, so I went anyways.
So what happened when you left the treatment facility? What did that mean?
I thought they had kicked me out.
Okay.
So
So you went to go see your brother?
yeah, I went to go see my brother and I did see my kids. And upon my arrival of seeing my brother, you know, he was snorting powder cocaine. So that started my races all over again.
Okay. And was powdered cocaine your drug of choice at the time?
One of them, yes,
Okay. And what was your other drug of choice at the time?
crack.
And what was your thinking when you partook in the drugs with your brother?
Now it's time to go and do what I do, which was crack. And I didn't have any more money. So I had a cell phone. So I was walking down the street and I seen the guy over there.
Okay, we'll get there. Just pause for a second. So was this on October 21st, 2006?
Yes,
Okay. And you mentioned you had a cell phone.
yes.
What significance does that mean?
That someone will buy it. They will give you money for it
And what did you need the money for?
to purchase crack.
Okay. And where were you walking down the street to do this?
On Cleveland
And do you know what city that's located in?
in East Point,
Do you know the county?
Atlanta.
I'm sorry?
I think it's Atlanta.
Okay. So you were in the city of East Point on Cleveland Avenue, right? And then you encountered an individual.
Yes.
Did you know this person?
No.
And do you see that person in the courtroom today?
Yes.
And can you please state where he is sitting and an item of clothing he is wearing?
He's sitting over there with the glasses on. And he have a white shirt, tan shirt.
Okay.
Let's see from here.
Can you identify what table, if he's sitting at a table or he's sitting in the gallery?
He's sitting at the table.
Okay. Your Honor, let the record reflect the inquiry identification of Mr. Williams by this witness.
She's done so.
What happened when you encountered him?
I asked him if he could help me sell my cell phone. And if he did, that I would split the product with him.
And why did you do that?
Because that's just how it go. If somebody sells something for you, you're supposed to look out for them.
Okay. And did he agree?
Yes,
So then what happened?
he sold it and he came back with the product and we smoked it on the outside somewhere.
And where were you when he went to go sell your phone?
I was standing waiting for him to come back.
Okay, so you did not go with him at all, right?
No,
What happened after you guys smoked that crack?
he said to me, hey, he said, if I get us something else, you willing to do something for something?
What did you take that to mean?
Meaning, was I willing to have sex with him for some crack?
And was that a commonplace thing?
That's how we did it on the streets.
And what was your response?
I told him yes if he brought me something back.
And then what happened?
And then he left. He left and he went somewhere and he came back. And then I said, well, where are we gonna go? And then he walked me to these buildings, this abandoned buildings.
Okay, so let's pause right there. I'm showing you what's been previously marked as dates 20 and 21. Do you recognize these?
Yes,
The second one too. How do you recognize them?
because that's where he took me,
What are they photographs of?
of the abandoned apartment that we went in.
And are they a fair and accurate representation of how those apartments looked on that day?
Yes.
Give me a moment to take a breath, just a moment. Your Honor, the state will move into evidence with three marked as dates 20 and 21.
Ms. Wood, no objection to states 20 and 21. They are admitted.
Okay, so let's talk about these photos. What is this a photo of?
It's the apartment.
And was there anybody living in that apartment?
No one was supposed to be living there because it was abandoned, but it looked like that someone had been there upon my arrival in there
How did you know it was abandoned?
because of the boards that was all over the doors and stuff.
And when you arrived here, what did you think was going to happen?
Well, I thought that him and I was gonna smoke and have sex and then we was gonna leave.
And how did you guys enter this apartment?
Through the broken window.
Is that what's pictured here in states 21?
Yes.
Okay, is there a pane in that window?
No.
And how did you enter through that window?
He helped me through it.
Did you go first or did he go first?
I can't remember.
Okay. But you willingly went in there first, right?
Yes.
Okay. Once you entered the apartment, what happened?
I said, okay, so show me what you got for me. And he said, man, come on, pull your clothes down. I said, no, show me what you got for me first, because I've been in situations where they, and he would never show me that he had anything.
Okay, so his part of the agreement had not been fulfilled, right?
No.
Okay, so what did you then do?
I said, you know what, never mind. I don't want to do this. I'm leaving.
How did he take that answer?
He didn't take it lightly. He grabbed me around my neck as I was turning to leave. And he said, bitch, you know what it is. Take it off.
Okay. Okay. So when he said that to you, what then happened?
So I took my clothes off. I took my clothes off.
For a second.
Ms. Jones, when you need a break, let me know and we'll break. If you want to keep going, we can keep going, but if you want to take a break? Want to keep going? Okay,
Yeah.
but just tell me when you need a break and stop and bring you back in when you're ready.
Okay.
Okay? All right. Why don't you ask your next question?
Did you agree to take your clothes off?
No.
And once you took your clothes off, then what happened?
And then he was raping me.
Okay, so how were you facing?
At first I was laying on my back.
And where was he?
He was on top of me.
And you said he was raping you.
Yeah.
Place his penis somewhere.
Yes, in my vagina and in my anus.
Okay. So at first when you were laying on your back and he was in front of you, right? Did that position change at some point? How did that happen?
Well, at first when he was on top of me in the front of me, he was choking me.
Okay.
And I told him, please don't kill me. I have kids. Please don't kill me.
How did he react to that?
He just rolled me over. He just turned me over. And then I had never been touched in my anus. And he just went in and just was having his way with me.
When you say he went in, what does that mean?
He penetrated my booty
With what?
with his penis.
And how were you reacting at this point?
I was letting him do what he was doing. But I seen a Coke 45 bottle beside my head
Why does that stick out to you?
because I wanted to hit him with it. But one man told me, don't. He might kill you and nobody know that you're here.
When just look up when you're ready. Okay. After he anally penetrated you, what happened?
Once he finished with me, he said, stop crying, stop crying. We finna go and make some money.
What did that mean to you?
Meaning he was gonna prostitute me so that we could keep smoking, I'm assuming.
Let's pause and go back to the apartment. What did it look like inside?
It looks like somebody had previously been there.
Was there any furniture?
No furniture, but there was sheet. There were stuff laying around, and there were the Coke 45 bottle.
Ms. Jones, I'm showing you what's in Crazy Market States 22. Do you recognize this?
Yes,
How do you recognize this?
because that's the sheet that it started on, him and I. Well,
What is the picture of?
it's the room where he took me to.
Is it a fair and accurate representation of how that room looked in October 26th?
Yes,
Sorry, 2006.
yes,
Your Honor, the state would move in what's been Crazy Market States 22 is that this?
Do you have a series of photos there you want to show her?
I
or
do, I was gonna go through each one. based
Let's
on-
get them all in now rather than one by one, and then you can publish them and ask follow-up questions.
Would you like me to go through the other photos as well then?
If you're gonna be having,
Yes.
sharing other photos with Ms. Jones, let's
Yes,
see if you can tender all of them and then can publish in the order you want.
All of these, please. Do you recognize those photos?
Yes,
How do you recognize them?
because it's me.
And what are they photographs of?
This is me. And this is the, the burn mark from the rug.
First photo posted to state 17.
Yes,
All right, state 18, what is that a photo of?
a burn mark from the rug. With,
State 19.
that's the carpet burn from the rug on my knees.
States 23.
That's the sheet with my blood.
Your Honor, I would tender into evidence states 17, 19, and 23.
Not 22?
And 22.
Is 22 something she's already looked at?
Yeah, sure, that was the one we were doing when you asked to.
Got it. Okay, and 22, there it is. Okay, any objection, Ms. Wood, to the admission of 17 through 19 and 22 and 23?
No objection.
They're all admitted.
Okay, Ms. Jones, let's talk about this photograph. Can you please explain again, what is this?
It's a photograph of the room that he took me to.
And you mentioned the sheet. What is the significance of that sheet?
Hmm?
The significance of that sheet, what happened on that sheet?
That's where he assaulted me on it, part of, on it. That's where it started, and then guess he got so rough that I got the carpet burns and stuff. I don't know.
Okay, so is that floor or carpet?
Yes,
And when did you get the carpet burn on your face?
when he flipped me over, when he turned me over. And
During the anal penetration?
yes,
What else do we see in this photograph?
it's a Coke 45 bottle.
And is that the one that you viewed during the assault?
Yes,
23. Is this the sheet?
yes.
And what did we see on that sheet? What is that?
It's mine.
How do you know that?
Because he raped me on it.
Were you bleeding after this incident? You remember where? I'm sorry.
Yeah, you have to say out, I know you nodded your head, but if you could answer.
Yes,
You remember where you were bleeding from?
no,
Remember you had injuries?
yes.
What is this a photograph of?
That's me.
Is that how you looked in 2006?
Yes,
What do we see in this photograph?
it's a picture of me.
And on states 18, what is that a picture of?
That's the carpet burn.
On your cheek there?
Yes,
19. What is that a picture of?
the carpet burn on my knee.
And that all occurred during the assault?
Yes,
Okay. Moving back to after he finished. Do you remember if he ejaculated?
I don't remember.
Do you remember if he used protection?
No, he didn't.
And he mentioned he was going to sell you, right?
Yes.
What happened after that?
Um, we went out of the abandoned building and he had my bag of clothes.
Why did you have a bag of clothes with you?
Why?
Yes.
Because my brother had my other brother had brought it to me. Because I was gonna change clothes.
Right.
Yeah,
Okay, so you had your bag of clothes with you and he had it, right?
yes.
Why did he have it?
I think that was his way of trying to get me to not run.
Did he allow you to take it yourself?
No.
And what did he say to you when you were leaving the building?
He said, we was walking in and he said, because it was a store right there and it was the super giant and it was a laundromat. And he said, you see that guy right there? I want you to go in there and make a deal with him.
And what did you take that to mean?
Meaning he wanted me to go and sell myself to him to try to make some money.
Okay, and what did you then do?
I went in, I went in the store and it was, I guess it was the owner of the store. He was up high, like the judge here. And I was able to come on the side. He thought I was going in to talk to the man, but I went in and I seen the clerk, the man of the store. And I asked him, I said, can you please call the police? This man just raped me.
Okay, and before you guys got to the store when you were walking, why didn't you run at that point?
Because he told me that if I told anybody, that he would kill me and leave me stinking and nobody would ever find me.
You said leave you stanky? What
Stank.
does that mean?
Meaning he'll leave my body somewhere and nobody will find me.
And how did that make you feel?
It terrified me. It made me feel that he really would do that to me and that I needed to get help.
And the store, was that the first opportunity you
Yes.
were not in his presence?
Yes,
And when you asked the clerk to call the police, what happened?
he did.
And did the police respond?
Yes,
Where did they meet you?
at the super giant. I stayed in the store till they got there though.
And did you talk to them?
Yes,
What did you tell them?
the same story that I'm telling here today.
Did you point out Mr. Williams?
Yes, I told them that he was, he's the guy standing outside the store with my bag in his hand.
Okay, and
And I described the color of the bag and what he had on.
they made contact with him at that point?
Yes,
Okay, and then what happened to you at that point?
they took me back to the scene.
What did you show them?
I showed them everything that we seen here today.
And did you eventually go to the hospital?
Yes,
And did you have a rape kit done?
I did.
Ms. Jones, I'm showing you states 27 and 27A. Do you recognize these?
Yes,
And is that your information on, it's on in here now, let me show it to you. On this sticker. Is that your information?
yes,
Is that your correct date of birth?
yes,
Is that from the hospital where you went for the sexual assault exam?
yes.
Railroad entering evidence states 27 and 27A as the sexual assault kit that Ms. Jones had performed on her.
Ms. Wood, we've talked about the origins of 27A and another witness will talk about that, but any objection to the admission of 27 and 27A?
I don't think the foundation has been properly laid for this. I'm not sure she would be the person who would have actually submitted or handled her kit
Or ever even seen it?
before, yeah.
Right.
Provisionally enter,
Are there questions you need to ask her about it, or why wouldn't we just hold off until you've got a witness who could say, that's my handwriting, or I created it, or I don't know why it would need to even be provisionally admitted now, but I don't want to interfere with your flow.
I have other witnesses that will testify to that. I would like Ms. Jones, she can testify this was the kit that was done to her. That she remembers having it done, so I can provisionally enter it, or I can have it entered through the other witnesses.
So why don't we do this? It's provisionally admitted, it's going nowhere until other witnesses who played a role in generating all that testify as well, and so we'll revisit it.
Thank you.
Does that work?
Yes, Judge.
Okay.
Ms. Jones, what happened at the hospital?
They, they did a rape kit on me.
Do you remember having the exam done?
Mhm.
Can you please describe what happened in that exam?
They had me take all my clothes off, and then they did something in my vagina.
You know if they swabbed your vagina?
Yeah,
And after the kit was completed, did you tell doctors what happened to you?
I can't remember, but
Okay. Did you talk to law enforcement again after that?
no, but I was still in my active addiction, so I had heard that they was looking for me. They had been through the area looking for me
And do you know what they're looking for you for?
for this case.
And you said you were still in your lifestyle.
Yeah,
Are you still doing that?
no, praise God. I have 13 years clean, coming up on 14 this year.
Congratulations.
Thank you.
And so you had no other involvement in this case, right?
Huh?
You had no other involvement at the time in this case?
No.
And that was because of how your lifestyle was?
Right.
No, I have no further questions, Your Honor.
Ms. Wood, do you have questions for Ms. Jones?
No, Judge.
All right. Do any of the jurors have questions for Ms. Jones? You. Counsel, we need to step outside for a sec. We'll be right back, Ms. Jones, okay?
So like, okay,
No, I said
Because we-
with one, that'll be happy.
correct.
Okay, good.
Thank you, Judge.
Sure. Ms. Jones, thanks for your patience. Tell the jurors, please, approximately what time of day this happened when you were taken to the abandoned apartment complex, et cetera. Was it daytime, nighttime?
Daytime.
Daytime. Would have been morning, afternoon? What's your best recollection?
I would say afternoon. I would say afternoon.
But you remember daylight as opposed to
Yes.
darkness?
Yes.
All right. And you talked about being threatened that you might be killed if you told what happened. Were you confronted with any weapon, or it was just the verbal threat of "I'll kill you" or "you'll be left stinking," whatever language you use?
It was what he just did to me and what he said that feared me.
Got it. When the police came and you pointed out Mr. Williams, what happened after that? Did they police take you somewhere else, or did you and the police go up to Mr. Williams, or what do you remember happening after you pointed him out?
I can't remember which way it went. I can't remember if they took me to the place first or if they had me to identify him first.
When you say took you to the place, meaning that abandoned apartment?
Yes,
Okay,
yes, but I do remember I had to identify him.
okay. Beyond identifying him, did you see the police interact with Mr. Williams at all that day?
Yeah, when they detained him.
Okay. Is today the first time you've seen Mr. Williams since that day in 2006? Or have you
Oh.
seen him since 2006, but before today?
I was just here,
Or a different court proceeding?
yeah,
Okay, and
So
did
he
you
was-
see Mr. Williams then?
yeah, that's when I seen, yeah.
Okay, and does he look different now or recently when you were in court than he did back in 2006?
The only difference is, I believe, is that he didn't have the glasses then.
Okay, but otherwise his appearance is
Yes.
fairly similar?
Yes.
All right. Ms. Reimer, do you have any questions for Ms. Jones based on those?
No, Your Honor.
Ms. Wood?
No, Judge.
All right, Ms. Jones, thank you for your time. You are free to go. Your next witness is, before you call the witness, it is,
Detective Weatherholt.
okay. Ladies and gentlemen, before Detective Weatherholt comes in, I want to provide a little context. The evidence you just received is being admitted for you to consider if it is relevant in any way to the charges that Mr. Williams faces. Mr. Williams is on trial for the alleged rape of Ms. Herring, not of anything you just heard about, but you may find the testimony you just received and the testimony of subsequent witnesses to be relevant in your determination of what happened during the incident, if there was an incident, in August of 2014. Ms. Reimer, if you would call your next witness.
Yes, Your Honor. The state calls Detective Jess Weatherholt.
Hello.
Raise your hand. You swear affirm that the testimony you will give is the truth, the whole truth, nothing but the truth, so help you God. Go ahead, have a seat. Can you state and spell your name for the record?
My name is Jess Weatherholt, JessWeatherholt.
Good morning, Detective Weatherholt.
Good morning.
Where are you currently employed?
I'm currently employed at the city of Fairburn
How long have you been there for?
since 2021.
Where were you before that?
Before my last policing job was at East Point.
Yes. And did you have a break between policing jobs?
I did. I was contracting in Afghanistan for a while,
Okay. How long were you with the city of East Point?
7 years.
And were you with them in 2014?
I was not.
I'm sorry, 2006.
Yes, I was.
Okay. Sorry. Are you post-certified?
I am.
And did you have any lapses in your post-certification?
No, took a break from 2010 to 21 when I came back in, but kept my post certification.
Okay. And what is your current role at the city of Fairburn?
Right now I'm a sergeant in charge of detectives.
And what does that mean?
CID, the investigation division, we investigate crimes once they come to us from patrol. And I'm in charge of divvying out the cases, managing caseloads and the detectives.
Okay. And what was your position at the city of East Point?
I was patrolman and SWAT.
And do you remember October 21st, 2006?
Yes, ma'am.
And were you called out for an incident?
Yes, ma'am.
What was that call?
I was called to a grocery store on Cleveland Avenue for a rape.
Okay. And you mentioned a grocery store. Is that grocery store still there?
No, it's not.
And do you know what's there now?
I believe Walmart.
And when you arrived to this grocery store, did you make contact with the victim?
I did.
Where was she?
She was hiding inside the grocery store, like peeking, trying to stay out of sight of the windows.
And why was that?
She said that she had just been raped and that her rapist was outside in the parking lot.
How did she appear to you?
She was very upset. She had an abrasion on her face, it looked like a fresh abrasion, like carpet burn.
Okay. And did she point out the person in the store or where he was standing in the store?
No, he was outside.
Oh, I'm sorry. While she was in the store, did she try to point out where he was?
She pointed it outside and she gave me the description of the clothing he was wearing and the bag he was carrying.
Do you remember what the description of the clothing was?
I believe it was a gray shirt and blue jeans. If I can check my report if you'd like me to.
Would that refresh your recollection?
Yes.
When you're done, please look up.
Yes. Yeah, she told me he was wearing a gray t-shirt and blue jeans and he was carrying a black bag.
Okay. Did she describe what was inside that black bag?
Eventually she did.
Did she describe what happened to her?
Yes, she did.
Did she say how she met him?
She said that they were walking in the same direction together on the street and they never met before that day. They just met up to walk together.
Okay. And did she say where they went together?
She said they were walking towards Cleveland Avenue and they cut through some old buildings as a shortcut.
And did she say what happened in those old buildings?
Judge, I'm going to have to object. This is hearsay, and also the state has been leading quite a bit.
Okay, less leading, and what about hearsay?
It's for the purposes of his investigation. He's speaking to the victim, and he's getting her present sense impression of exactly what happened and while she's in the store and why she's afraid of the person who's outside.
Okay, but you don't need to object again. I will ask you to rephrase future questions if they're eliciting what I deem to be hearsay as opposed to present sense impression, like I was walking down the street with him. That's something she testified to, and we don't need to hear what she said to someone else as opposed to how she was feeling or how she appeared.
Okay.
Okay.
Yes. Did you learn where they went?
Yes, she pointed out the building that they went to.
Did you go to that building?
I did.
Do you know where that building was located?
It was located behind the grocery store.
Do you know the address of that building?
It was North Friedel Circle, maybe 801 or 803, North Friedel Circle.
And is
You say
that,
the name of the street again?
North Friedel.
Friedel?
Friedel. Yes, sir.
does that street still exist?
No, it does not.
Okay. Do you know what's there now?
The Walmart parking lot.
Okay. What city, county, state is that apartment located in?
That was East Point, Georgia, and that's Fulton County.
Okay. Did you learn what happened inside that building?
Yes, ma'am.
And through your investigation, what did you learn?
She told me that he forced her through a window and told her if he didn't do it.
So I'll interrupt. You're being asked questions that are tricky for you to answer without getting into what Ms. Jones told you. But I'm going to ask Ms. Reimer not to ask you questions that require you to say, this is what Ms. Jones told me.
Okay.
So you should ask a different question now, Ms. Reimer.
Did you view the inside of the apartment building?
I did.
What did you view?
There was a mattress, I believe, laying on the floor. There was a white sheet laying on the floor with looked like blood and some fluids on it.
Yes, that one. Yep. I'm showing you what's been previously marked as states 22. Is that how the apartment looked?
Yes, but I believe so. The white sheet, yes.
Okay. And the next states 23. Did you ever observe this sheet?
Yes, I did.
And what is that on there?
It appears to be blood and some kind of fluid.
Okay. And how did you know that's what that was?
Well, just through my training, knowledge, and experience, know what blood looks like on a sheet.
Okay. Before you went to the apartment, did you make contact with the defendant or the person she said it was?
I did.
And did he match the description she gave?
He did.
The bag that she had, did you go through the bag?
I did.
What was in the bag?
It was women's clothing. If you can, I can look at my report to refresh my memory for the
If-
exact clothing.
That would refresh your recollection.
Yes. It was a black DKNY shirt, a pair of jeans, and a black sweater.
Okay. And did that match the description of the clothing that you were told would be in the bag?
Yes.
What did you then do?
I informed him he was suspect in an investigation I was conducting, and I identified him, placed him in handcuffs to detain him, and did a quick search, and he had a crack pipe in his pocket. So at that time, I arrested him for loitering for illegal purposes while we conducted our investigation.
And then was he identified by Ms. Jones as well?
Yes.
Based on your investigation, was it consistent with everything you learned from Ms. Jones?
Yes, everything she told me was true.
Based on what you
That's
found?
based on what I found, yes.
I have no further questions, Your Honor.
Ms. Wood, do you have questions
Yes, Judge.
for this witness?
Just a few, Judge.
Okay.
Hi, is it Sergeant Weatherholt?
Yes, ma'am.
Thanks for being here. You mentioned that you went to the apartment, correct?
Yes.
And you saw a mattress and a sheet and some other things, right?
I did see the sheet. I can't recall the mattress, but I think there was a mattress, maybe. I'm sure.
You saw things in the apartment, okay. Do you know if that was collected to be sent for testing?
I believe it was. We called our crime scene unit to the scene.
But that would have been someone else's job, not yours?
Yes.
Okay. And that would have included the Colt 45 bottle or can that was there as well, correct?
I can't speak to that. I didn't collect any evidence.
It's fair to say that all of that evidence collection would have been someone else's job.
Yes, ma'am.
Okay. Thank you. No further questions.
Any redirect?
No, Your Honor.
Juror questions? You? Sergeant, were you involved in transporting Ms. Jones to the hospital for an examination?
No, sir, I was not.
Do you know what happened with Mr. Williams just that What time of day was this that you responded to the call? If you need to check your report for something that happened 19 years ago, that's okay.
Says I responded at about 4:15 PM, sir.
Okay, so 4-ish in the afternoon. You mentioned that you took Mr. Williams into custody for loitering, et cetera.
Yes, sir.
What was the next procedural thing that happened with him? Did you then release him? Did he get
No,
taken
sir.
to a jail or what happened?
He was taken to the jail by another patrolman that was on the scene.
Okay,
And
would that have been in jail in East Point or to the county jail?
East Point, it was a city ordinance charge for East Point.
Okay,
And from there, detectives would have been conducted their investigation and concussioned him there at the start.
okay. You didn't have a role in anything that may or may not have happened with Mr. Williams after he was taken from the scene in a patrol car?
No, sir, I did not.
Got it. Ms. Reimer, any other questions?
No, Your Honor.
Ms. Wood?
No, Judge.
Sergeant, thank you for your time.
Thank you, Your Honor.
Appreciate it. Ms. Reimer, your next witness will be roughly how long? I'm trying to think, sort out whether we take our morning, we haven't been going very long, but it's 10:30, so that's sort of the midpoint.
I don't believe she'll be very long. It's Miss Robinson's witness and she just stepped out.
Okay. Well, if she's back shortly, we'll do that witness. Otherwise, since she's not here, take the break. Hey, Ms. Robinson, are you ready for the next witness or?
Yes, Your Honor.
Great, and that is?
State called Detective Wilkins.
You can raise your right hand. Do you swear affirm that the testimony you will give to the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Still in have a seat. Can you state and spell your name for the record?
Natasha Wilkins, Natasha Wilkins.
Good morning.
Morning.
Where are you currently employed?
I am unemployed. I am retired.
And where'd you retire from?
City of East Point.
How long were you with City of East Point?
26 years.
And in what capacity?
Pretty much everything.
Okay,
Field training officer, detective, sergeant, lieutenant, and captain.
okay. And when you retired, were you a captain?
Yes, I was.
Back in 2006, what was your title?
I was a detective.
And I just want to direct your attention to October 21st, 2006. Did you have an opportunity to respond to 801 Friedel Circle?
Yes, I did.
And what was your purpose in responding there?
We were responding to a rape call.
Okay. And when you responded, were you responding as the detective or a lead detective assisting?
Yes, I was one of the assistant detectives.
One of the assistant detectives?
Yes.
Okay. And when you responded, did you have an opportunity to meet with the victim, Miss Lucenda Jones?
Yes, I did.
And did you take her to Grady for her sexual assault kit?
Yes, we did.
And did you also prepare search warrants for anything in this case?
Yes, she knew who the offender was, so we prepared a search warrant to collect his DNA.
And was that search warrant signed by a judge?
Yes, it was the Honorable Judge Oliver.
And were you able to collect this, the suspect's DNA?
Yes, we collected the DNA on a buccal swab.
And I am approaching you with what has been previously marked as State's Exhibit 29. Do you recognize State's Exhibit 29?
Yes, this is the buccal swab collection kit.
And is your name anywhere on that kit?
Yes, it is.
Okay. Does it appear to have been altered?
No, it does not.
Your Honors, at this time, the state enters into or moves to admit State's Exhibit 29.
Ms. Wood, any objection?
No, Judge.
And so I'm clear, it's admitted, this is a buccal swab purportedly taken from Mr. Williams, not from Ms. Jones.
Correct.
Okay.
And we're gonna come back to the buccal. Actually, let's talk about the buccal swabs. How do those work?
It's a non-invasive way to collect someone's DNA. It's like a big Q-tip swabbed inside the mouth, and then it's sent to GBI for analysis.
And so the big Q-tip, do you take it out of a kit of some sort?
Yes, it's all in the kit. You take it out of the box, you do the swab, you put it back in the tube, and you seal it back up.
And do you swab the entire mouth or just the cheek area, or how does that work?
It's just both sides of the cheeks.
And once you swab both sides of the cheek, what do you do with that swab?
You put it back into the sealed container and then back into the envelope.
And whose cheek did you swab for those buccal swabs?
That was Mr. Williams, J. Scott Williams.
And I want to move to October 26th of 2006. Excuse me. Did you have an opportunity or did you attempt to make contact with Miss Lucenda Jones to interview her?
I did.
Okay, and were you able to make contact with her on the 26th?
On the 26th, yes.
Excuse me, on the 23rd?
On the 23rd, no, she wasn't at the location of her address.
Okay, and where was her address at that time?
The Efficiency Lodge.
And so did you attempt to locate her again?
Well, we did, but I think she actually came to our office on the 26th.
And were you able to interview her on the 26th?
Yes, we did.
Okay, and did she advise you that she was raped?
Judge, again, getting into hearsay.
In your honor, it's a prior consistent statement.
So I don't recall Ms. Wood asking any questions of Ms. Jones.
Okay.
So I don't know that prior consistent statements would come in at this time.
Okay, thank you, Your Honor.
Sure.
And where did you meet Ms. Jones to do this interview?
At the East Point Law Enforcement Center.
And was this interview recorded in any way?
Yes, it was a digital voice recorder. It was probably put on a disc.
Okay. And after interviewing Ms. Jones, did you take out arrest warrants?
Yes, we did.
Okay.
Hold on 1 second.
Judge, I was gonna object for a leading question.
Oh, that's okay. Overruled.
Thank you, Anna. Could you answer? I'm sorry.
Yes, a warrant was prepared for the rest of the offender for several charges.
Okay. And were you also able to collect evidence from Ms. Jones?
Yes, on the day that we spoke to, we collected her clothing and we put that into evidence as well.
Okay. And what did you do with that evidence?
We logged it and tagged it and put it in brown paper bags and submitted it into our evidence locker.
One moment, please. I'm going to approach you with State's exhibits 24, 25, and 26. Do you recognize State's Exhibit 24, 25, and 26?
Yes, I did. I completed those.
And when you say you completed those, is your name somewhere on these bags?
Yes, they are.
And what are these bags?
They're filled with clothing that the victim wore.
And does it appear to have been tampered with?
It does not look like it. No.
Your Honor, the state moves to enter into evidence State's Exhibits 24, 25, and 26.
Ms. Wood, any objection to those three exhibits coming in?
No objection.
They're admitted.
Thank you. And so once you bagged and tagged these items, what did you do with them?
Submitted them to our property and evidence custodian.
And were they then placed in a secure location?
Yes.
Did you have any other involvement in this case?
Not that I can remember.
Nothing further. Thank you.
Ms. Wood, any questions for retired Wilkins?
No, Judge.
All right. Any questions from the jurors? You. All right, lawyers, I need to talk to you for a second. Be right back.
Thank you.
Can you remind me what your final rank was when you retired?
Captain.
Captain, I'm gonna call you Captain. Captain, share with the jury, please, what you remember about how Ms. Jones appeared to you. You took her to the hospital that day?
Yeah.
You the one who transported her? Her demeanor, her appearance, how did she appear to you when you took her to the hospital that day?
She seemed upset. She was distraught. So, or she was an abuser of drugs, so she was still a little, I guess, inebriated, but she seemed like she was telling the truth. And
I'm not asking whether you believed or disbelieved her, but just if you know, was she crying, was she angry, was she scared, or what your impression of her was then?
she was scared and she was upset.
Okay.
Physically.
You mentioned that, were you the one who secured the arrest warrants? Or you just know that that happened in the course of the investigation?
No, I actually prepared the rest.
Okay, and got Judge Oliver to sign them?
Yes.
Okay, what happened with those warrants then? Were they executed on Mr. Williams?
I believe they were, but unfortunately, I don't see a supplement stating what date that occurred.
Okay. So we've heard from another witness that Mr. Williams was at least taken into custody that day on a loitering charge. Do you know if the warrants that you took out were ever used to keep Mr. Williams in custody at any point? Or that's what would be in the supplement, and so you don't know?
That's correct.
Okay.
And that's when we were able to obtain his DNA when he was for the loitering charge.
Okay, that was my next question. So Mr. Williams was in custody when the buccal swab was conducted or performed?
Yes.
And then do you recall what the outcome was, if there was any outcome, for the charges for which you swore out the warrants?
I understand the victim was unable to come to court. And so,
Okay, thank you. Ms. Reimer, Ms. Robinson, do you have any questions for Captain Wilkins based on our exchange?
No, Your Honor.
Ms. Wood?
No, Judge.
All right, thank you for coming here. You are free to go.
thank you.
Ladies and gentlemen, we're going to take our morning break now. It'll be at least 10 minutes. We'll get you back out here when we are ready to tell you what's happening next. Remember, during the break, no outside research. Don't talk about the case, talk about anything else at all. You're free to fan out on the hallways, and hopefully your restrooms are working. We'll see you in a little bit.
All right, Lucenda.
All right, let's all sit down and figure out what we're doing the rest of the day. I'll start with the state.
Your Honor, that was scheduling, that's the witnesses that we have for today. We are not happy about it, but that is, we can get Ms. Fowler here, but she's a short witness. And then the rest would have to be when their schedule is for tomorrow.
So what you have remaining is, well, of course, we get your investigator here.
Yes.
All right. You have remaining Fowler, Dixon, John, Whitmore,
Yes,
4 witnesses.
yes.
Anyone else?
No, Your Honor.
And of those 4, who takes the longest?
I would say, yes, investigator John and Miss Whitmore.
How long do you forecast investigator John's testimony to be?
And yeah, about an hour. And,
Okay,
I would, if we were gonna do him today, I would ask to do it after a lunch break. He's been running around with witnesses and on the phone.
okay. I think that's what we're gonna need to do, but I wanna hear from Ms. Wood. I'm assuming you're not enjoying this awkwardness for the state, but it's basically a not my problem situation. Is that a fair assessment?
Correct.
Okay.
This is a them problem. not a
Okay.
problem.
Got it. And you don't really have a basis to object to the order in which the state calls its witnesses. You're just ready to go with your presentation. Okay. Then, Ms. Reimer, my proposal, if you want to not call investigator John now, would be that we'll break for an early lunch and I guess I can consult the jury to see what they want to do. One thought would be we break for lunch and just come back at 1 so that it's sort of a normal lunch hour, as it's a 2-hour lunch, and they may not want a 2-hour lunch because probably 60% of that they'll just be sitting in the jury room looking at each other. We could break for lunch now for an hour and basically say at noon we start up again. And I'd let them know that we'd be done by probably 1:30-ish at the latest, and then we're done for the day. Do you have a preference as to, hey, we're giving you a real long lunch break and we'll start up 1-ish, but we're still going to end early, versus let's be back in an hour? I don't even know they can get lunch yet. I don't know when places open up.
11.
Okay. All places open at 11?
Well, the Fuda, I know, opens at like
Fuda
11.
opens at
We
11.
would have this too.
Oh,
Oh, they won't have to worry about running out. Fuda will certainly have a lot at 11. Do you have a preference?
I do. I'm sure it's not the court's preference. I would prefer the longer lunch, based off of investigator John running around.
Okay. Can he be here at noon, or he is somewhere far away?
I know he was, running around with witnesses. I could see if he could be here at noon.
Okay, I just I'm gonna let the jury decide. But I don't want to give them an option that's not an option. So, if he can't be here ready to go at noon, then we might as well just say 1 o'clock, because then it would be, okay, we'll start at 12:30, but I guess that still is a slightly shorter break.
Just.
You can be ready to go at noon if needed, Your Honor.
Okay. Why don't we take 5 minutes? How long have they been in there? Okay, why don't we take 5 more minutes and then we can, then there will be another break. So don't panic and say, wait, my morning break was so short. It'll be at least another hour. Let's get back together at around 11 on that clock. We'll bring the jurors out and get their sense of what they. How about this? Do you have any objection if I dispatch Deputy Gordon into the jury room, giving them the two options so they can speak freely and it's not one of these awkward, they're looking at each other in the jury box. We'll bring everyone back out in about 10 minutes to hear from the jurors. Any issue with that, Ms. Reimer?
No, Your Honor. That's
Okay. Ms. Wood says it's okay too. You understand what the choices are? Either we basically break for lunch now and start up at, we'll say, noon, 12:10, or we give them a longer lunch break and start at 1. Either way, we're done mid-afternoon today. Okay, thanks. I'll be back out in a little bit.
Can you send me your question?
All rise adjourned. Doing the further in the counter for.
Thank you, Deputy Gordon. You all can be seated. So, ladies and gentlemen, we are working through some scheduling issues for witnesses. There is a witness who is flying in from the West Coast who was supposed to be here today, but there were some flight mix-ups. That witness won't be here till tomorrow. We're still on track for the state to rest tomorrow. I am asking the state to take witnesses out of order. So the story of the state's case may come across a little choppy to you, but I want to use your time while you're here. There's one witness remaining that we can get into the building today, and that person can be here noon-ish. So Deputy Gordon told me when he canvassed you all, the majority view was take lunch now, and maybe we'll start up at 12:15. That witness will be here. My guess is that it'll be an hour, hour and a half-ish for that witness. You've been pretty inquisitive, so maybe a little longer based on your questions. Then we're done for the day. And we won't reconvene until 1 because of the drug court obligations that I have tomorrow morning. But we remain actually ahead of schedule in the sense of how the timing of the two cases are going. I have some things I can take up with the lawyers when you're not here to try to be efficient that way. But we are going to need to end a little early today. I'm sorry. We are using your time as efficiently as we can, but there's no point making you sit around when we don't have witnesses here. So you should take your lunch break now. I've been assured that the usual lunch spots open at 11, so they're already open. The Fuda over in the government center or down on this floor, the bottom floor of this building, and any of the surrounding venues should be open by now. Is there anyone who needs more time than 12:15? Okay, and you don't have to go if you want to fast and eat afterwards. You can do that as well, or just feed off the endless supply of snacks that we put in that little white basket. Appreciate you rolling with this flow, but it's how trials are. Everyone else has a life too, and we're pulling them out of those lives to be here and share their testimony with you. Any logistical questions? Yes, sir.
Are we still starting Thursday at 10?
Yes, that hasn't changed either, but I'll remind you of that tomorrow. Have you all conferred to see if you can stay till 6? I don't think that's going to be necessary, but was there anyone who said, no, I can't do that? Okay, so the plan for tomorrow is 1 to 6, but hear me now and hear me again. We probably won't go that late. The state will likely rest, and then when the state rests, I mentioned this in my opening remarks to you all, we have to pause. So I have to take up a bunch of things with the two sides after the state rests. But we may fill out all those hours. And then, yes, we'd start up at 10 on Thursday. And that would then otherwise be a normal day, go until 5-ish. If we even get that far, you may have the case in your hands for deliberations at some point on Thursday. That would be my expectation. Other logistical questions? All right. Remember, no outside research. Don't talk about the case. If you all dine together, talk about anything else. And we'll see you at 12:15. Thank you. All right, Ms. Reimer, anything else before we start our lunch break? And this schedule is gonna work for your situation.
I'm gonna have to make it work, Your Honor.
All right, appreciate that. Ms. Wood, anything?
No, Judge.
All right, we will see everyone at 12:15. Thank you.
Island time.
It is definitely pollen time.
Every time.
Oh, yeah,
I'll call you every day.
yeah. Well, you need to buy a yellow card and you won't notice that. When I was growing up, my dad had a old VW that was, there wasn't a lot of pollen when I grew up, but it was a pollen colored car. I said, sweet, I have to watch this thing. It was an ugly car. Thank God, that's where we need to go. Ms. Rivers, you ready? We're back on the record in State versus Williams. It is about 12:15, 12:20. All our jurors are back, if they even left. We'll bring them out in a minute. Ms. Reimer, I think the plan is for you to call investigator John to testify. All right, any other witness updates? Okay, then we will, once the jurors are in, you can call him. We'll get through his direct and cross and the inevitable questions from the jurors. And that will be it for evidence. I have a draft jury charge, and I'll tinker with that some. We're gonna do our charge conference today. We can take a break if we need to for whatever duration after investigator John has testified. But then we'll regroup and knock out the charge conference today. I'll push that draft out to everyone in advance. We can take our time going through that, but that way we will have checked that box. There may still be something in flux. We haven't even heard from the defense, but we can get 85, 90% of the charge in place. Anything else from the state?
There.
Ms. Wood from the defense?
No judge.
All right, Mr. Williams is here, so let's bring the jurors in.
Oh, okay. Other than that.
All right, Ms. Rivers. I'll do the president county court.
Thank you, Deputy Gordon. Everyone else can be seated. Welcome back from your early lunch. We are going to take up one more witness as advertised before we took the break. Ms. Reimer, if you would call that last witness for today.
Yes, Your Honor. The state calls senior investigator Samy John.
Raise your hand. You swear affirm that the testimony you will give will be true, the whole truth, and nothing but the truth, that God. Can you state and spell your name for the record?
My name is Investigator Samy John, SAMMYJOHN.
Thank you. Where are you currently employed?
Currently employed with the Fulton County District Attorney's Office in the Sexual Assault Kit Initiative Unit, which is known as the SAKI unit.
Okay, and what is your position there?
My position in the unit is I'm a senior criminal investigator.
Where were you previously employed?
I was previously employed at Chamblee Police Department.
When?
I was employed in Chamblee from August of 2016 till May of 2019. And before then, I was employed at Crisp County Sheriff's Office in Cordial, Georgia, from February of 2012 to August of 2016.
Let's go to your employment at Chamblee. What was your position there?
My position there at Chamblee Police Department, I was a patrol officer.
And what was your duty there?
My duties as a patrol officer was to answer calls, assist anybody in the community with any issues that they were having. I was a liaison there as well. I also helped investigate cases that would help me also lead to any kind of arrest.
And your position at Crisp County, what was your position there?
I was a sheriff's deputy there at Crisp County, and I also was a supervisor in the detention area.
What was your responsibilities?
My responsibility was to go out. I was serving paperwork, also helping out with cases. I also helped out with any type of assaults, murders, any type of robberies, mainly cases that would have been crimes against people.
Are you currently post certified?
Yes, ma'am, I am.
Have there already been any lapses in your post certification?
No, ma'am.
Going back to your current position in the SAKI unit.
Yes.
What is the purpose of the SAKI unit?
The purpose of the SAKI unit is to investigate cold case sexual assaults.
And why was it created?
SAKI was created because there was a backlog in sexual assault kits that was found at Grady Memorial Hospital back in 2015.
So you mentioned cold case. What is a cold case?
A cold case is a case that was previously investigated. And a detective or officers who had the case ended up investigating the case over a number of years. They came to a stop in the case because they were not able to, to obtain any more information. So the case was not closed, but it was sitting there. So that date or the years could possibly go from 5 years, anything over 5, maybe 7, maybe 9, anything that's a long period of time.
And is the SAKI unit a large unit?
No, man, we're rather a small unit.
Who's in this unit?
It'd be 2 investigators, victim witness advocate. It's also maybe 2 attorneys.
Are we part of that unit?
Yes, ma'am. Yes, ma'am.
And what do we do in this unit?
In this unit, we investigate cold case sexual assaults. We have the sexual assault kits or a picture from the sexual assault kit. We get the information from the kit, varying from a possible suspect, it could be from a victim. They also have maybe whoever the doctor or nurse, anybody that's on the kit.
Let me pause you there.
Yes,
Step back. How does a case come into the unit?
Oh, case comes into the SAKI unit after the kit is sent off and tested for the GBI. When a DNA hit comes back, we get that hit, and then our attorneys in the unit, they end up assigning the cases to the investigators.
And does that trigger your investigation?
Yes, ma'am, it does.
And what do you do as part of, how do you start your investigation?
So again, I start my investigation by gathering as much information as I can. If there's information, again, from the sexual assault kit, a possible police report, medical report, any type of evidence, anything from it, I try to get all that stuff and put it together so I can start building my case from the ground up, because that's essentially what we do inside the SAKI unit.
Okay, and do you work with the entire team?
Yes, I do.
Why?
Well, we work with the entire team because we want to make sure that we're getting, as a collective, that we're getting enough information as we can. So once it's time for us to start reaching out to our victims that's in the case, that we're able to build the case to try to, make it more stronger, shall I say.
And is there any reason why you work together to deal with the victims?
Yes, so we work together to deal with the victims because, again, man, these victims have been through so much. These victims have, at one point, they've talked to police officers, they talked to detectives, they've been to the hospitals, and at a point in time, these victims have been through a traumatic experience. Over the years, these victims have not heard from any officers, anybody. So at that time, they may feel like they have not been heard. So by the time we reach out to the victims and everything, we want to make sure that we're building a rapport with the victims, because again, we're complete strangers once we start talking to the victims, and we're trying to make sure that we're again building that same rapport with them.
And let's talk about building that case from the ground up.
Yes, ma'am.
Police reports. Do you always have police reports when you start your investigation?
Sometimes we have police reports and sometimes we don't have them.
What do you do when you don't have a police report?
When I don't have a police report, I still try to get as much information as I can. If it's not from the police report, we try to get it from medical records. We may reach out to a neighboring agency or whoever the agency was out of, and we try to speak with detectives or any officers or anybody, so we could try to get a sense of what they did or if they whatever role that they played within the case.
Are you sometimes able to gain a case file?
No, ma'am. Not all the time.
But sometimes you are?
Oh, yes, ma'am. Yes, ma'am.
And are those case files always complete?
No, ma'am.
And typically what is missing from a case file?
It could be anything missing from it. It could be the police report could be missing from it. It could be an evidence list. It could be it could be just normal things that's within that case file.
And why are these case reports, case files, police reports sometimes non-existent?
They're non-existent because, the cases are so old. Again, the cases can go back. You can start from,
Hold on.
no, sorry.
Please continue.
Yeah, so like I said, these cases are so old. So sometimes the police departments, if the cases have not been investigated or anything, the case files will be put away. And you have officers who will leave the police department. You have evidence techs, everybody who decided to go work somewhere else. And so it takes a lot of time and preparation trying to get all that stuff together so we can help build the cases.
And when you do have a case file and police reports, what kind of investigations do you come across?
Sorry, can you repeat
What
that?
kind of investigations? Complete investigations, incomplete investigations, what kind?
Sometimes we come across complete investigations. Sometimes we come across some investigations where the investigation started and then the investigation may stop. And then maybe another officer may have, or the investigator or detective may have picked up that case at a point in time. Along with that, it could be some of the officers, the detectives may have gotten evidence at one point in time. They may have some other officers may have investigated it further, and they may have gotten some. And then sometimes we've had instances where we have had those cases and we didn't have any.
When you come across a case that had an incomplete investigation, what does that indicate to you?
That indicates to me that either the agency stopped the investigation at that point in time, or maybe that the detective or whomever that was investigating the case was not able to find too much of anything.
And you mentioned medical records.
Yes, ma'am.
You always find medical records.
No, ma'am.
And why is that?
Because when we reach out to the hospitals, we send out we send out a production of evidence subpoena to them, and we have them send us back whatever medical records that they have from the time of the incident date to whenever the victim leaves the hospital. Once once Grady sends us the medical records back, the medical record has enough information on there or some information to where we're able to gather, let's say if Grady sends me a report over and let's say I don't have a police report. I can get information from the medical records that can help identify the victim. They might have given me an address. It might give me some type of initial information, and then it may also have maybe even like a little small narrative, so I can try to learn what happened within that case.
And do you sometimes not have anything besides a sexual assault kit?
Yes, ma'am.
What happens in those cases?
In those cases, if I don't have if I don't have anything but the sexual assault kit and I have no police report, no medical records, I'll go from there and try to find some type of information on the victim, and I'll just make a cold call to them.
Okay, and when you have just the sexual assault kit, are they always complete?
No, ma'am.
Okay, and how do you find information when you have an incomplete sexual assault kit?
When I have an incomplete sexual assault kit, I will call over to Grady Memorial and see if Grady would have any information from that day when the victim came in to the hospital. And then hopefully from there, it will be some type of attempt that we can possibly find that sexual assault kit. But we've had instances where it was not possible.
You mentioned a cold call. What is a cold call?
Okay, so a cold call would be if we use any or numerous investigative databases that we hear at the DA's office. I would enter the victims. Let's say if I just had a name, first name, last name, I would enter it in, and it will give me information that would come back to possible victims. I would basically get all the numbers that populated from it, and I would just start from the top number, and I would call each number going down the list.
Why do you do that?
I do that because, again, I'm in hopes of trying to find maybe a family member or maybe someone that would pick up that might have heard from the victim, and also in hopes that, maybe, that the victim would themselves actually pick up the phone. Is
that typically successful?
Not all the time. No, ma'am. Not all the time.
So what do you do when it's not?
Oh, yeah. So when it's not successful, I would then go from even using just the phone numbers. If we have possible relatives, we have possible addresses, I go get out into the streets, and I would drive and check addresses and just just knock and talks and try to see if the victim may still live at that possible address, or if it's a family member or anybody, and just try to, just have a general conversation and ask them how the victim, if they still remember the victim. If they do, how the victim is doing. Have they seen the victim? Do they know what type of if the victim's married, single, divorced, something that would give me some type of information so I can try to locate the victim.
Are your victims always local?
No, ma'am.
And what do you do when you don't have a local victim?
So when I don't have a local victim, if I am able to contact the victim and we are speaking with them, just like I said, try to have a conversation and see if they're comfortable with trying to have an in-person meeting.
And if they are, will you travel to them or make them come here?
Oh, yes, ma'am. We would definitely travel to them. Like I said, if that's comfortable in their safe space. If not, we always extend that possibility. If they would like to come to the office, we have also a setting that we can go and try to speak with them as well.
And why do you do it in that way?
Well, I do it in that way because, again, these victims have been traumatized. And also they're meeting a complete stranger. It's not always common that you have somebody who will be more susceptible after being through a very traumatic experience. And then again, they don't, they may not trust the police departments. They may have been wronged by a police department. They may think that it's think it's a scam. We've had people who think that we were scamming, but at that time, like I said, our jobs is to try to build that rapport with them and also let them know that we are victim centered and that we're there for them.
And why would they think it's a scam? You mentioned that.
Because again, like I said, they've been wronged. And you talk about cold cases, there's been a long gap between when these victims had spoke with somebody all the way until the day that we reach out from the DA's office. Normally, they may sit and watch a television show or something and think that, hey, I spoke with somebody and I talked to them the next day. And sometimes it doesn't happen that way. But we do ourselves try our best to reach out to them and just try to get a comfortable surrounding for them.
Are you often the first time they hear from law enforcement since their case happened?
Yes, ma'am.
Let's go back to gathering as much information you have.
Okay.
Before speaking to a victim.
Okay.
Why do you take those steps to gather all that information before you actually speak to a victim?
Well, I want to gather as much information as I can because, again, I want to make sure that I am being, again, victim-centered to the victims. I want to make sure that I have as much information as I can because once I start talking to them, I want to be able to build my case from the ground up. Because again, I may not have a police report, I may not have medical records, I might be missing something. But by the time I reach the victims and I start speaking with them, these victims are able to tell me their story. And along with them telling me their story, I'm trying to see what I have and and what they're saying. That way it gives me direction in which I can go and try to dig deeper or go further into the investigation.
Do you find sometimes speaking to them is triggering?
Yes.
Please tell me about that.
So when we begin speaking with them on the telephone calls, we would have victims who would always sometimes they're very, very hesitant because again, I'm bringing up something that happened to them, something that really, really bothered them, or something that they had to try to fight a battle themselves to try to come out of a dark light. So as I'm starting to ask these questions to them, I've had instances where these victims would get silent. They would get very emotional on the phone. They would cry. And, I want to be able to give them that time, to try to pull themselves back together.
Do you make these phone calls alone?
No, ma'am. When I make my phone calls, it's myself, the victim witness advocate who comes in, who also this person is like a guide for them, is more like very helpful, trying to coach them through the hard times that they have, and also the attorney.
And when you first make contact with a victim, how do you confirm who they are?
So when I make contact with the victims, what I do, I'll start off, like I said, having a conversation with them. I will reach out and I will ask them, can they confirm like date of birth or any type of, personal information. Then from there, I ask the victim if they were a part of an incident that happened around the date and time. And from there, I sit back and I try to listen to the victim, and the victim will either sometimes remember it, sometimes they may not remember.
Okay, when they remember it and you confirm it's them, what do you then do?
Once I confirm that they remember it and it is them, I ask them, would they be open to having an in-person conversation with our office?
Why is it an in-person conversation and not just over the phone?
So the in-person conversation is so I can build that rapport with the victims. A lot of the times, it's easy for them to pick up. Sometimes it's easy, for them to pick up the phone and have that conversation. But I want them to actually put the face to the voice, for them to actually know that we are serious about helping them get through, get to this case. And I want to really see what's going on, because a lot of times if you don't do it that way, they may pick up and then you may try to reach back out to them. And again, they may have, like I said, I just scratched off a scab off an old wound. So they may not pick up the phone. You could try to reach out to a family member. A family member may, try to assist you, but they also understand that family member as well, the victim, has been through a hard time. So if they're open to agreeing to meet with us, then yes, we go to them, and that way they'll understand that, that we're really here for them.
You mentioned victim-centered. Is this part of that?
Yes, it is.
So can you explain more what victim-centered means?
Exactly how it sounds. Like I said, the victim is at the center of everything that we do when it comes to an investigation and to this case. Like I say, the victims, at a point in time, they felt alone. So again, we want them to be as comfortable as possible when we're speaking to them, because if not, then like I said, they could be the possibility they could shut down, or they could tell us like, hey, I'm just, I'm still not comfortable. But again, if they're not, then we address it from there.
Do you find that there are trust issues exist sometimes?
Yes, ma'am.
Please tell me about that.
So again, at one point in time, once the victim opened up, they spoke to different medical personnel. They've spoken to different officers. They've spoken to maybe on-scene officers, investigators. Sometimes they will say, tell everything that they have. Sometimes they're not believed. Sometimes these victims are, they get to a point to where they shut down and they don't feel like nobody's really trying to understand them. So with us, like I said, we want to make sure that we give them the floor so they can, they can express everything that went on. And then from there, we just try to get them into a safe space where they're ready to talk.
And after you have interviewed the victim in the case, what is your next step?
After interviewing the victim in the next step, I'll take everything that I got from that interview. I do a report, and I also keep investigating the case further on, and I just try to keep digging and get as much information out as I can.
Once you've made a determination in your case, do you typically take out a warrant?
Yes.
And did you become involved, or were you assigned a case and an investigation regarding Jess Williams?
Yes, ma'am.
And do you see that person in the courtroom today?
Yes, ma'am.
Please state where he is sitting and an item of clothing he is wearing.
He is sitting over at the second table. He's wearing black glasses. Excuse me. Says a yellow shirt.
Let the record reflect the in-court identification of Jai Williams.
You'd like me to reflect the fact that Investigator John identified Mr. Williams?
Yes, the in-court identification by this witness of Jai Williams.
That's what happened.
Okay. And how did your investigation into this case begin?
So my investigation into this case began once I received, like I said, the DNA hit. I started investigating it along with a police report that I had, medical records, and also the sexual assault kit.
Did you have a full police report?
Yes, ma'am.
Was it a full case file, rather?
No, ma'am, it was not a full case file.
Okay, what was missing from the case file?
These photos were missing from the case file.
So what did you do to get those photos?
So I reached out to East Point Police Department, to the property and evidence unit. I sent multiple requests over. I finally did receive something back from one of the sergeants that was over there, and they said that they would get back to me whenever they were able to locate.
Did they locate any other evidence?
They were able to locate physical evidence, but I did not receive any photos.
Did the office eventually get photos from East Point?
Yes, ma'am. Yes, ma'am.
And did you have medical records in this case?
Yes, ma'am.
Okay. Did you have to request them?
Yes, ma'am.
And how did you go about doing that?
I went by requesting the medical records by sending over a production evidence subpoena to Grady Memorial Hospital.
And once you received the medical records back, what did you do?
From there, I added those medical records to my case file.
Did you find in your review of the police reports and case file that a thorough investigation was done?
A thorough investigation was not done.
Okay, so what was your next step based off of that?
So my next step, I sat down and I tried to break everything down piece by piece. I went through the police report, and basically I was trying to see where the incident occurred, who was, the initial officer. I just tried to take every step possible so I can make sure that I wasn't trying to leave anything out. From there, I ended up trying to, like I say, get in the evidence and trying to see if there was anything that was also matched from that police report into the evidence, and also anything that would have came from the, as far as the sexual assault kit to evidence.
And after you reviewed everything, did you make a determination on whether or not you were going to reach out to Ms. Herring?
Yes, I did.
And what was that determination?
That determination that I felt that I had enough as far as the police report, medical records, and the evidence that I just want to reach out so I can start having a victim notification with her, the initial contact call.
Okay. Tell me how you contacted Ms. Herring, the steps that you took in order to get in contact with her.
Okay, so in order to contact Ms. Herring, I ended up, like I say, getting the information on the reports, sexual assault kit, and the medical records. I ended up entering that information into one of our databases or numerous of databases that we have here at the DA's office. Once I was able to receive, like say, possible addresses, possible phone numbers, possible relatives, email addresses and everything, I ended up going through all that information and I was basically dialing each phone number that we had, number by number by number. And I eventually was able to speak with a family member who was able to get us in contact with Miss Herring.
Okay, so when you spoke to Ms. Herring, how did you verify that it was her, the right person?
Okay, I verified that, excuse me, I verified that that was Miss Herring by using her date of birth.
Okay, and how else? Anybody else?
Well, besides using the date of birth, I also just confirmed with her about the incident date as well. And then Miss Herring was able to come out and kind of tell me something like, yes, I remember this date. And she said that she had been sexually assaulted around that time.
When you asked her about that, how did she respond?
She instantly got quiet on the phone. I could hear her getting very emotional. It's more of sounding like she was crying. She had sniffles. She said she needed a minute. I could hear her on the phone just saying that, oh my God, oh my God.
And how did you react? How did you react to that?
I instantly wanted to make sure that, that I wasn't pressing Ms. Herring. I wanted to make sure that she understood that, that this conversation was, it was for her. It was about her. I told her that I wanted to be patient with her, give all the time she needed, and just let her let me know when she was ready to speak.
And were you able to speak with her that day?
Yes, ma'am. We talked for a little bit, but the gist of it was trying to see if she would be willing to meet us in person.
Was she willing to meet you in person?
Yes, ma'am.
Where was she living at the time?
She was living in Macon, Georgia.
So, where did you agree to meet her?
It was a restaurant that was in Macon.
So who went with you to this meeting?
It was myself, a victim witness advocate, my supervisor, and one of the ADAs from the office.
Again, why do all these people go with you to meet with the victim?
So again, because that's our team. That's these people went with me because one, like I said, our victim advocate is the person who comes there so she can help, speak with her, console her. If there's any resources, anything of the nature, she's able to assist Miss Herring with it and also give her that comfort because we know that it's gonna be, it's gonna be a tough conversation. And if we have it, but we want her to know that we have someone there that's gonna help her build through that. As far as the investigators and the assistant district attorney that comes with us, like I said, they're there so we can try to speak with Ms. Herring so we can find out what she remembers from the case.
And who did Ms. Herring come to the meeting with?
She came with a support system. She came with her mother and also she came with her small daughter.
And you mentioned as part of your investigation, the ADAs, the assistant district attorneys go down with you.
Yes.
And why do they go with you? Do they ask the questions or do you ask the questions?
Oh, no, ma'am. I'm the one that asked the questions mainly. Like I said, they're there as a listening ear as well in the case because, like I said, we all investigate the case together.
What about the legal questions?
As far as the legal questions, if the victim has any type of legal questions, then yes, I'm not able to answer those. The attorneys will answer those.
Can you tell me, you may have already said this,
Yes, sir.
I missed it. This first interview or meeting with Ms. Herring happened when? Or have we not said?
I didn't ask that.
Oh, no.
I'm asking.
Okay.
When did it happen?
I believe it was 2023.
We're looking at your report, refresh your recollection.
Yes, ma'am. May I look at my report?
All right.
Thank you. Yep. So September the 7th, 2023.
And that's when you met with Ms. Herring?
Yes, my first initial time in person meeting with Ms. Herring.
Okay.
Yes, sir.
How many days or weeks or months before was that phone call you described where you made contact and had the reaction you heard her have?
So typically, when we make those, the first victim notification calls, we usually try to schedule the in-person meeting 2 weeks, within 2 weeks.
Okay, so it wouldn't have been a year before, it would have been fairly close in time to
Yes, sir.
that meeting.
Yes, sir.
Okay, thank you.
Just a follow-up on that, why do you try to do it 2 weeks later?
We try to do it 2 weeks later because we want to, like I said, we want to still meet with the victim because, you know, if you sit there and you wait at a long period of time, the victim may feel like that we were not sincere, we were not really trying to meet with her, or like, again, she may feel like it was a whole scam or anything.
You work around their lives and schedules?
Yes, ma'am.
Okay. Moving back to the meeting with Ms. Herring, the attorneys are present. Do they ask the difficult, sensitive legal questions?
Yes, ma'am, they do.
And are they typically female?
Yes, ma'am.
And why is that?
Because, like I said, Miss Herring is she was sexually assaulted. So a lot of the female victims at that time, they're not comfortable with a male asking them those type of questions. They get to a point to where if a male is trying to lead them into those questions, they will break down on you. They will shut down. So typically, before it even gets to that part, I ask the female victim if they're comfortable with me asking the question, or would they like our assistant district attorney or the female officer, if female officer comes with me, to ask those sensitive questions.
And Ms. Herring's interview, how did it start?
So Ms. Harris' interview started, basically I asked her, how her day was going. I introduced our unit, the Saki unit to her and everybody that came along. Then from there, I just basically asked Ms. Herring to just try to give me a recount of what happened.
So you don't jump right into the interview, right?
So this is a preventative objection, don't want to get into because I don't think that question, you don't jump right into the interview called for hearsay, but you don't want to get into the contents of the interview.
Right, I jumped up when he said asked her.
Got it.
And didn't want to.
Okay. So were you planning on asking Detective John to say, here's what Ms. Herring told me?
Eventually, Your Honor, and I have a response. It is Ms. Herring testified and she was cross-examined by defense, and based off their questions, the implications, this is a prior consistent statement that happened years later, and it's showing that she's consistent from the time in 2014 to when she was part of this investigation. And based off the cross-examination, that is why I'm asking Investigator John what he learned during his investigation.
Okay, so unlike Ms. Jones, Ms. Herring was cross-examined. There may be areas where prior consistent statements are admissible because they rebut attacks on credibility. But you'll need to be surgical in that way because, just I'm using it as an example, it may be that Ms. Herring told this witness it was dark out. I don't know that that was attacked in the cross-examination, but if there are areas that you felt there was pushback from the defense through cross-examination of Ms. Herring, and there are prior consistent statements, then I think they would be admissible as an exception to hearsay. But it would be different than, I'm not saying this is gonna be your question, tell me everything Ms. Herring said. So you said we're not there yet. When we do get there, I'm gonna require you to be surgical in that way. Did she say anything about X? And X would be an area where your position is Ms. Herring was impeached or challenged or attacked in that area. Does that make sense?
Yes, Your Honor.
Great. And Ms. Feely, you're gonna map this as well. And if we have to talk outside the presence of the jury about really was that an area where there was possible impeachment, we can do it. But I'm hearing Ms. Reimer say that she's going to stick to those areas as opposed to a blanket. Hey, just tell me everything Ms. Herring said. So I'll rely on you two to navigate that, and I'll be here.
Okay, so let's go back to why you don't jump right into the interview. Why do you ask about the victim beforehand?
So I ask about, sorry. Yeah, so I ask about the victim, beforehand because, I want her to get to a sense of where she's comfortable with still having the conversation with us. I could tell that from the time we had the first victim notification with her to the time when we first met her in person, she was nervous. You know, and I think it's because, again, we're peeling that scab off. And I think that she had time herself to actually go and reflect. So you could tell when she was sitting there, she was a little fidgety, a little nervous, not really a lot of eye contact. But I could tell that was coming from because she was still, trying to remember, trying to get herself through that part of the conversation.
Okay. And do you find that's common when you do victim notifications?
Yes.
And from your review of the file that you had in your possession, did you learn anything new about the case from Miss Herring?
Yes.
What was that?
So I was able to determine where I guess from the beginning, from where Miss Herring, when she left from the very first part of the case, and then as she traveled down Cleveland Avenue, and when she made contact with a male suspect.
Okay, so you were able to gather her route that she walked from?
Yes, ma'am.
Okay. And anything else new from that specific meeting with her in Macon, Georgia?
Not as no, ma'am.
Okay. So then was the information you learned consistent with what the information you had that she gave officers in 2014?
Not everything, no, ma'am.
Please tell me about that.
All right, so it started from, I guess that would have been after, I guess, once she made contact with the suspect.
So that would be something different. So what
Yes, ma'am.
different did
Sorry.
you learn?
All right, so what different from what I learned is the contact portion of it. Miss Herring told us that she met, when she was walking out Cleveland Avenue, that the suspect approached her. She said that she had her earbuds in, and she really wasn't, trying to pay anyone attention. She just was trying to get to where she was trying to go. She said that the male approached her. She said that he offered her some money in order to see her body. He said nothing sexual, and Miss Herring said that she turned him down.
One moment. Okay, so did you learn the location of the incident?
Yes, I did.
Where was that?
So the location of the incident from what Ms. Harris told was at 920 Reed Avenue.
What city, county, and state was that located in?
That is in East Point, Georgia.
And during the interview, how was this?
During the interview, I could tell that Miss Harris started she started kind of breaking down on me because as she was remember certain stuff, she needed a moment. She was, like I say, crying. She was, her anxiety was getting to her, and as she continued through the interview, it was difficult for her.
Did she have an explanation as to why?
Yes, she said that.
Same objection, hearsay, I just don't, she's testified and this is still now, of course, that's new information.
Okay. Response? How would this one be a prior consistent statement that is the subject of something that was challenged earlier this week?
Can I review the notes from the prosecution?
Sure.
Yeah. That's all it touched
Okay.
on.
Okay. Your Honor, it's not part of the prior consistent statement based off the notes. It is not being offered for the matter of the truth asserted. However, it's outgoing to the victim's state of mind while she was speaking with Investigator John.
Okay, repeat your question.
My question was, how was she when you, or what was the explanation she gave you as to, why she was breaking down? I believe that's my
Okay.
question.
All right, I'll allow you to answer that. Go ahead.
So, like I said again, Miss Heron was telling me that that she was feeling very overwhelmed because again, this is something that she was replaying in her mind over and over. Miss Herring was just trying to, account for the things that had happened, but in between of the times when she was telling me, she just was getting really, really emotional. She had, like I said, had to stop a few times. She started, like I say, her anxiety was getting to her, and it's something near sort of like panic attack. But I think because, like I say, it had been so long, and she started coming back around with it. I think that's the reason why she really was more emotional.
I want to go back to one of the things, you stated that she had such an earbuds in. When looking at your report, refresh recollection as to what she said.
Yes.
Specifically, page 4,
One second.
paragraph 5.
Say page 4, paragraph 5. Yes, ma'am.
Did she have earbuds in?
Hold on, one more second, sorry. Oh, no, my apologies. No.
What was she doing?
She went as she was walking down Cleveland Avenue, she was acting like she was on the phone. That's my apologies.
About how long was he meeting with Miss Herring and Megan?
I believe the meeting was probably over an hour, maybe an hour and a half.
And how did this meeting conclude?
So the meeting concluded after speaking with Miss Herring. Let Miss Herring, we thanked her for her time, let her know that would be getting back in contact with her as well. We came back to Atlanta.
Except for the one thing you know that was different, was everything else consistent with what was reported in 2014?
Yes.
Did Miss Herring agree to participate in prosecution at this point?
Yes, she did.
Okay, and what was your next step after this meeting?
After that meeting, once we got back to Atlanta, I tried to take all the information that I gained from Miss Herring during the interview, and then I basically compared that to police report, medical records, anything I have, and I just tried to keep furthering my investigation.
Stepping back one moment, I forgot, overlooked something. Was this the first time Miss Herring had been contacted by law enforcement since 2014?
Yes, ma'am. That's what she told us.
Okay, so you get back to Atlanta and you're doing your investigation. Did you speak to anybody else as part of the investigation?
We ended up speaking with her god sister, Miss yes, I do. So Miss Jasmine Bailey.
And why did you speak to her as part of your investigation?
Because I wanted to, because that's where the home that she initially left from, and I just wanted to see what Miss Bailey could remember.
Anybody else that part of your investigation to further your investigation?
Besides Miss Bailey, I believe I spoke with her brother.
Why is that?
Because her brother was the one when he was 11 years old. He had actually comforted Miss Herring. Miss Herring had a rough time going through it. She did not want to be left alone. She had nightmares. She couldn't sleep, and she said that she found a sense of comfort from her 11-year-old brother actually, sleeping with her.
Did you, after you completed, was this the end of your investigation, or did you do more?
As far as for that, yes, ma'am.
Okay. Did you meet with Ms. Herring again?
Yes, ma'am. We did meet with Ms. Herring again.
Where was that? Was it Macon or was it Atlanta?
Atlanta.
And what was the purpose of that meeting?
So the purpose of that meeting, so we could, I could have Ms. Herring in the car with myself, the victim witness advocate, and also the prosecutor, and we rode through the crime scene.
And where did you start your travels?
So I started my travel from the Oak Drive location where where her goddess Miss Jasmine was staying, and we drove the route from Oak Drive down towards first part was where the McDonald's in East Point, and then we ended up asking Miss Herring if any other locations looked familiar, and then from there we left. Went down to where the gas station was. She was asked her if anything looked familiar from there. And then from there, we went to Reed Avenue, the address of Reed Avenue.
Okay. And did she have any difficulty leading you through her route that she walked?
No, ma'am.
Okay, I'm showing you what's been previously entered as states 2. What is this a map of? Can you see?
Should be in front of you also.
It has stay muted or
Click stay muted. You got it.
I got you. All right. Yes, ma'am. This would be the photo of the route.
Okay, are you able to show us the route that she walked or drove you through?
Hold on 1 second.
This is also hearsay, Judge. She told him the route that she took and she's already.
So my understanding is they drove a route. What I just heard the question was, what's the route you, investigator, drove with Ms. Herring? So now we're describing investigative activities that occurred in 2023 or 2024. If I misheard the question, then I need to reconsider your objection. But why don't you ask the question again so it's clear on the record and we're all hearing it? Because you did say walk and then you said drove.
Yes.
So which one is it?
Can you please tell us the route that you drove with Miss Herring on the day you drove with her in East Point?
Yes, I can.
That's a touch screen.
So if you tap the screen once in the lower left-hand corner, there will be a circle with a pencil in it. Tap that circle. It's probably blocked by the microphone a little bit, but you see that circle where you can move the screen if you need to. So tap the screen once. No, there you go. Now what's in the corner? All right, there you go. Now your finger is empowered.
Alrighty. So starting from where Miss Herring's, where Miss Herring,
Where you walk,
Yeah,
where you drove her, yes.
Here, came up to corner.
Is it showing up on your screen? There we go.
Yes, I'm sorry.
Okay.
We are making that right and coming up to where Cleveland Avenue was.
And once you got to Cleveland Avenue, where did you go?
We made a left onto Cleveland Avenue. And we drove for a little while till we got to where I say that's close down where the
Did you find that was consistent with information you already had?
Yes.
Did you also go out to the location?
Yes, I did.
Why?
I went out to the location to see if the abandoned house was still up, was still there. And upon my investigation going out there, I did not see the house there. There was a bunch of shrubbery, bushes that were very, very high. You could not see anything past possibly the driveway.
Why would you go out to the scene, or to where she described the scene was?
Because I wanted a firsthand look of how the crime scene looked at the time.
Did you
After you completed your investigation, what was your next step?
After the investigation was completed, I ended up, obtaining warrants.
And did you also obtain a warrant for a vehicle swap?
I did.
I got you. Oh.
Sorry. I'm showing you what's been previously marked as safe receipt. Do you recognize that?
Yes, ma'am, I do.
Okay. What is it?
On here, this is the, buccal swab kit or buccal swab, kit.
And what's included in that kit?
Inside the buccal swab kit, you have, two packages there on the inside of the kit. They also have two long stemmed Q-tips that are also on the inside of the kit, two that I'm able to swab the right cheek, two I'm able to swab the left cheek. It's also another evidence part that's to it, an envelope that you will put inside it so you can seal it. And I will sign it with my initials, and then I put it back inside of the buccal swab collection kit, and I will initial it so I can turn it into the Georgia Bureau of Investigation, GBI.
Before you even open the kit, what do you do?
Before I even open the kit, I'll make sure that I have my gloves and everything on. So because I don't want to make sure that I'm contaminating the kit.
And so did you execute a vehicle swab search warrant?
Yes, ma'am, I did. I went over to the Fulton County Jail with the kit and the search warrant, and I also had a copy of my search warrant. So once I got over, I walked to the back, placed my gloves on. I went and waited for the sergeant to bring the defendant out. And once he walked in, I introduced myself to the defendant, and I also explained why I was there, which was to get a swab of his epithelial cells, cheek cells. And I showed him the search warrant that was signed by the judge. I gave him a second so he can look through it and read it, because I don't want to just get it and then he feels like, that something was happening. So in front of him, I also opened the kit at that time so I could show him that the kit was not tampered or anything was messed up with my kit. From there, I ended up taking out the right side, which had the two, the package with the two swabs in it. I swabbed his right cheek. I placed it back in, getting one for the left cheek, swabbed that side, placed them back in, placed them inside of the kit, sealed them, make sure I signed them right stand there, and then we put it back in initial. And then after they took Mr. Williams back.
And what is the purpose of getting vehicle swabs from the suspect?
So I can have a confirmation swab to connect, or excuse me, just I can have a confirmation swab that would be associated with the DNA of the suspect.
Is it to make sure that's the correct person?
Yes, ma'am. Make sure it's the correct person.
Okay. And after you took the swabs, what did you do with the kit?
After I got done with those, I ended up and sealed it. I ended up leaving there and transporting these to the Georgia Bureau of Investigation.
Okay. I want to go back a little bit.
Okay.
Is it typical, you said in this case you had an incomplete investigation?
Yes, ma'am.
Is that typical in these kinds of cases?
Yes, ma'am, it is.
And is that why you do what you do?
Yes, ma'am. Is very common because, again, a lot of the cases that our unit works, these cases are so old that you may have officers who have left, some who have retired, some who may have passed away, or just went on. And a lot of the cases may have been passed to a newer investigator or somebody who was reassigned. They may have gotten a promotion. So again, our job is just try to reach out and speak with them. So the whole end goal is so we can make sure that we're getting enough information and the correct information so we can give justice to the victim. Sorry.
Do you physically go out and try to locate witnesses? And
Yes, I do.
why is that?
We try to physically go out and locate the witnesses because a lot of times, the information that we get from our databases, the information could be wrong. So whatever possible lead that I may have, we leave the office and we go knock on doors, or if they have anything as far as like work information or business information, besides trying to call them there or either trying to get them on the telephone through a family member, we will go out and try to knock and just see if they would have a moment of their time, see if they would be willing to speak, or if they do say that they remember it, just try to see what they remember from the case.
When you find that there are incomplete investigations, and how do you find that the victims feel about that?
What's the relevance?
That Ms. Herring testified how she was made to feel by law enforcement in this case. So it's just finding out if it's typical in these kinds of cases, since they are cold cases.
So you could ask him what's typical in a case, and see where that goes and see if that elicits an objection.
Okay. After you did the buccal swabs, did you do anything else as part of the investigation in this case?
I believe I did. Yes, ma'am. Yes, ma'am.
What else did you do?
Again, just kept trying to work through, try to work through the case to see if there was any more evidence or anything that we could obtain.
Okay. I have no further questions.
Yes, ma'am.
Is Feely, questions for Investigator John?
No, Your Honor.
All right. Members of the jury, questions for Investigator John? Take your time writing them down. In the future, only one side of the card, please. It's for record keeping purposes, but we have to make this part of the court's record later on. All right, Investigator John, we'll be right back. Question. Investigator John.
Yes, sir.
Can you share with the jury your best guess slash estimate of the percentage of case files that you get when you're handling cold case, percentage of them that come to you and they're incomplete? You're thinking, hey, there's more work to be done versus complete. Yep, Now that we've got this hit, we just need to get the person and we're off and running.
A percentage.
Yeah, is it all of them are incomplete, all of them are complete, 50-50, and it's just an estimate?
About 85-90% of those are incomplete.
Incomplete,
Incomplete, yes, sir.
okay. What is the oldest case you've dealt with in the soccer unit?
Ooh, 1984, 83, 84. Yes.
Do you know, without getting into the legal niceties of it, whether there's a statute of limitations on the kinds of cases you work on?
I don't know if I can answer that per se.
I'm not asking you what it is. Is it 5 minutes or 10 years? But are you aware, is there a statute of limitations that can apply to say too much time has passed?
Yes.
And so you get it saying, hey, we've got a match, but it's too old. We can't do it.
Yes, sir.
Okay. Get to that in a minute. Tell the jurors what you'd seem to distinguish between a completed investigation. You mentioned most of the things you get are not complete versus a completed case. Are those interchangeable terms or are they different?
I would say that they're different.
Okay, tell the jury the difference between a completed investigation and a completed case.
All right, so a completed investigation would be, it could range from me starting from getting the first piece of evidence all the way through everything that I have done. As far as my report, me speaking with victims, witnesses, also speaking with the doctors, any what they call outcry witnesses, could be like a family member, anybody of that nature. Going out to the crime scenes, anything that I would do for as far as my investigation for the Fulton County District Attorney's Office SOCI unit. For the completed case, it would still, that would be the whole entire going back to what the police, what the police departments have, as far as if they had their own swabs or anything that they've got through the GDI, anything as far as their particular case file itself.
When you are working on, this is a generic case, when you're working on a case that comes to you because there's been a hit, and maybe there are multiple hits, do you focus solely on the victim in the case file you get, or do you sometimes reach out to victims, maybe their cases are closed for whatever reason, but they end up being connected to the work you're doing?
Oh no, I reach out to the victim in our case because that's how they're assigned. Once I'm investigating the case that I have, I try to make sure I do everything in my power that's possible to try to make sure that I can get everything for them. From there, if it's something where I'm speaking to my attorneys or anything else that are another witness that is considered I guess 413, then we can reach out to them. But normally when we get our cases, it's for that specific victim.
So you used the term 413. Yes. Tell the jurors what you meant by 413.
413 would be a victim that something with prior acts. So that would mean that let's say if I have a victim and this is their case, that's theirs. If it's a DNA hit that comes back that's associated to that possible suspect, then I can reach out to the other would be a 413 victim, or let's say that their case has already, let's say if it might have went to court, it might have already been open closed, I would reach out and speak with them.
I want to talk a little bit about, have you talk a little bit about the timeline of this case. Tell the jurors when it was you started working on this case. If you need to check your report, you can do that, but I don't know if you've got, hey, it was September 9th of this year, or it was this month of this year, whatever the year was. But when was it that a file shows up on your desk, or however it is, where you are beginning to do work on the case?
When I first started with the case, I got the case, I believe, around like April or May. I would say May of 23. And I started from then just trying to get as much as I can as far as information and doing my background stuff before I got to a point to where I was comfortable with reaching out to the victim.
So April or May of 23, you get the case, you're doing your due diligence, and then when was it that you reached out to Ms. Herring? That call, which then 2 weeks later led to the interview in May.
I believe that would have been middle of August, I believe, close to the end, because again, we in our unit, we try to have, once we make that contact, we try to contact our victim within those 2 weeks. Well, excuse me, we reach out, contact the victim, then try to meet with them those 2 weeks later.
So you make the phone contact, a couple of weeks later, there's the Macon interview.
Yes.
And then you mentioned you swore out a warrant or warrants based on your investigation. When did that happen?
Oof. But I know I swore excuse me. Give me 1 second. Let me.
Okay.
Tag date. I believe it was around December.
Of 23.
23, yes.
So it's subsequent, it happens after.
Yes,
I'm
sir.
sorry.
I'm sorry. No, after, like I said,
After Macon.
yes, sir.
Okay, so you get the case file, phone call, Macon, warrants, and then buccal swab? When did you do the buccal swab? Before or after you swore out the warrants?
No, I did it before. Yes, sir.
You did the buccal swab before you obtained the warrants for Mr. Williams?
Yes, sir. Hold on. Sorry, Judge. He was in custody. He was in custody once he got arrested, went to the jail. Then I was able to do the swab.
You got arrested on your warrants?
Yes, sir.
Okay, so the reason why Mr. Williams was in jail at the time you did the buccal swabs was because of the warrants you took out?
Yes.
And why did you do buccal swabs of Mr. Williams if what you had received, because of the CODIS, it was Mr. Williams's name already?
Because I wanted to make sure that I had what's called a confirmation swab. That confirmation swab would let me know that the DNA from that point in time in the case was consistent with the DNA of the defendant.
You mentioned in your testimony that there were aspects of the original police investigation into the allegations Ms. Herring brought, which she said happened to her, that there were aspects that weren't thorough. Upon your review of the file or whatever's been going on in the case since you got it, what did you find was missing or lacking or wasn't as complete as you would have wanted if you wanted to get a complete case file?
Okay. From there, it would have started from when Ms. Herring spoke to the first responding officer. After speaking with her, she ended up speaking with, I guess, the officer once they established jurisdiction. From there, from established jurisdiction, it was, like I say, it was just, I didn't feel like it was enough there for me just to say, hey, I think that it was enough. I wanted to dig deeper in it, like say dates, times, whether it was light outside, dark outside. Did Ms. Herring encounter anyone else when she was walking the route? I wanted to make sure that I was covering every basis that I could, because I knew that just because the police department did their investigation, it's always more to it than just that first initial. So my job is, I come from the behind part of it, and I want to check if she remembered, if there was anything that's that was out of the ordinary. If she remembered something that stuck out to her. Well, again, it wouldn't just be that one little thing, even from the beginning all the way to the end.
Ms. Reimer? Any questions for Investigator John
Yeah.
following that?
I do. Investigator John would, looking at the rest of your case file, refresh your recollection as to what the dates were for the warrants.
Yes. Copy of that. Okay, got my dates wrong, okay.
So when did you swear out your arrest warrant?
Swore the arrest warrant on August 27th of 2014.
Nope, when did you
Nope.
swear out your arrest
Sorry.
warrant?
The arrest. Oh, my apologies. October 11th,
Of what year?
2023.
Okay, and when did you swear out the bugle warrant?
People warrant. April 30th, 2024.
When did you execute that warrant? Meaning,
May of 24.
okay, what does execute a warrant mean?
Executing the warrants with that, I took the search warrant, went over to the Fulton County Jail, and I ended up swabbing Mr. Williams.
Okay. So you said that Miss Herring's case was not a thorough investigation.
No, ma'am.
Did East Point Police Department do much in her case?
They didn't do a lot. No,
And
ma'am.
why do you think that?
Because
Calls for speculation.
I don't think it calls for speculation. It calls for his opinion. If you think he's not qualified to offer that opinion, you could examine him on that when it's your turn.
I'll ask it in a different way. You said that East Point did not do much. Did you base your investigation off of what East Point did not do?
yes,
Okay. And I'm sorry, you can ask, Your Honor, you said he could answer that question, why he thought that?
I did.
I'm sorry, can you please answer why you thought they didn't do an investigation properly?
because there were a lot of missing like items that were missing. Let's say pieces of report, evidence wasn't there. We was trying to reach out and speak with some of the officers. It was a lot missing. Yes, ma'am.
Okay. And you mentioned that you reached out to another victim, or you reached out to other victims, right?
Yes, ma'am.
Okay, so did you reach out to another victim in this case?
I did.
What was her name?
It was Miss Lucenda Jones.
Did she remember the incident?
Her incident, yes.
Yes, her incident.
Yes,
And when did her incident occur?
in 2006.
And do you know what happened with her case?
Her case was dismissed,
Why was that?
but she did not show to court.
And do you know why she didn't show up to court?
She missed court. Whether they wasn't, I believe she called the prosecution, or excuse me, the attorney's office the next following day.
Go back to your first page. Nothing further, Your Honor.
Ms. Feely, anything?
No, Your Honor, thank you.
All right, Investigator John, thank you for your time.
Thank you, Judge.
Ladies and gentlemen, we are finishing for the day. The good news for you is that we don't call your employer or anyone else to say, hey, we ended at 1:52. So you're welcome to go back to work or go home, or it's a beautiful day out, go to Piedmont Park and walk the active oval. Your $25 covers the whole day. Prorated for the fact that you put in only a partial day. That's not on you. The lawyers and I are going to do a little more work today after you go. We're going to have what's called a charge conference where we go over the law that I'll be giving you at the end of the trial. And we will start up tomorrow at 1 o'clock. That was regularly scheduled for us. So 1 o'clock tomorrow, please, if you are a lunch eater, have eaten your lunch before you get here, or bring it and get here. I'll be here at 8:30 in the morning, and your jury room remains your space. So if you're already feeling a nice way about things, show up at 8:30 tomorrow. You can have that space. But if you want to bring your lunch and eat it here, that's great. We will not have a lunch break. We'll have a normal afternoon break partway through our 1 to 6 window. But as I mentioned, we might not even fill that window based on the pacing that the state's managed to put together for the case so far. They just had a couple witnesses who couldn't make it today, and they hoped they could make it today. And then they'll rest, and we'll see if the defense is going to put on a case. No burden on the defense. Don't have to put anything up, but they have the ability to do so if they want. During your extended break away, remember not to talk about the case. Don't do any outside research. Limit your questions to those 3x5 note cards, one side only, and we'll handle it that way. Any logistical questions from anyone? Sir?
When you say we're tracking early, are we still tracking to, is it before, I guess, at 5 p.m. on Thursday? Or what do you?
So I bet you'll get the case to begin your deliberations sometime on Thursday. Your deliberations are going to take as long as they need to take. So making the numbers up, you get the case at 3:30 on Thursday. We can go up until about 7:30 when you're deliberating. We go as late as you want once you're deliberating. It's your clock rather than a community clock. But you might want to end at 5 or 5:30, and that might not have been enough time to deliberate, in which case you come back on Friday, whenever you want to come back. You could say, just because of traffic, it's easier if we start at 10. And if that is the collective will of the jury, then at 10 is when you come back. So what I don't ever want to do is say, yes, but you have to fit all your deliberation into that little window. So I'd be surprised if you don't have the case well before 5 p.m. on Thursday. Have the case, meaning you're beginning your deliberations. Those take as long as you as a group decide that needs to take. Did that answer your question? Okay. Any other questions? Oh, yes, ma'am.
So we would have to possibly come back Friday.
You've always been able to come back Friday. That was always our arrangement, is that people were there. There was one gentleman who had a flight on Friday. He didn't make it onto the jury. So yes, you might have to come back on Friday. It's possible that the defense is going to carry the case into Friday, but their current forecast is that they won't. And so I suspect you'll get the case, be able to begin your deliberations on Thursday. And Thursday can stretch later if that's what you as the deliberating jurors want to do. But you also have told me you can be here Friday. If you're here on Friday, it would only be for deliberate. I just don't foresee that on Friday there's still evidence coming in, or we haven't had closing arguments, because we're going to take care of this charge conference today after you leave. We'll be ready to go straight into closing arguments once the defense rests. But they cannot start their case or rest their case until the state rests. The state will rest mid-afternoon tomorrow based on the number of witnesses they have left and what I think those witnesses have to share with you all. Okay, so be open and excited about Friday, but that really depends on how tomorrow, and it'll be a reason to go all the way to 6 if we've got stuff to do it, because then it might be that Thursday's just deliberations, and you might be able to reach a verdict or whatever you're going to do if you've got all day Thursday. Okay, anything else? No, thank you for your time. Notepads stay in the jury room.
All right, good.
Okay, we're gonna have our charge conference this afternoon. We can have it when you all would like to have it. Do you need a break, Ms. Reimer?
Yes, I do, Your Honor.
All right, is 2:30 too soon? And I'm not rushing, you can say 3 o'clock, but we all have to sort of hang around until we do the charge conference.
I understand. I was not able to take a break during the lunch hour. So
Because you had to get John ready. Got it.
I would
prefer to be able to do a full 30 minutes if I could.
Let's do it. So how about, if we reconvene at 2:45?
Perfect.
Does that work for you, Ms. Wood?
Yes, Judge.
Okay, and we can keep Mr. Williams here if you want to talk to him about whether he wants to be here for the charge conference. Absolute right to be here. May not want to sit through that. So why don't you guys chat with him and then just let Deputy Gordon know if he doesn't want to be here, they can start processing him out. Otherwise, you can take off. I will be back out here with Ms. Rivers at 2:45. I'll email you all a draft of the charge in a few minutes. I have one more tweak. And I'm letting you know right now, I have no idea what we're gonna say about statute of limitations because of the DNA clause in there as well, but we'll discuss that starting at 2:45. Thank you.
Now look up. I'm gonna leave this here. I'm gonna look up the, do they file the charges? It's gonna say from like the other cases.
We should.
Yeah, I'm gonna look that up.
Bless you.
Yeah.
Okay. Oh, that's that. It's fine. He's doing something.
Yeah, sorry, I'm just.
Oh, yeah.
Ms. Rivers, you ready?
Yes.
Okay, we are on the record once again on Tuesday, the 25th in State versus Williams. Mr. Williams is in court with his lawyers. We have our prosecutors here, and we're going to have our charge conference. The jurors were sent home early today. They'll be back at 1 tomorrow. And I emailed to all four lawyers, maybe half hour ago, a little bit longer, a draft of the charge. Ms. Reimer and Ms. Robinson, the way I go through the jury charge is I'm going to stop in this draft in places where I had a question. But in doing so, I may skip over an area where you had a question. Why isn't this in here? Why is this in here? So I'll jump to page X, whatever it is, and we'll start talking about that. And then you can say, hey, go back to this because I'd like to talk about it. Ms. Wood and Ms. Feely have survived this approach before. And then when we're done, if there are things that I hadn't included that we didn't discuss, because we'll talk about some of the things that I've struck through provisionally, and you'll know those aren't in. But if when we're done, there are things you're wondering, why aren't they in there? It'll say, hey, what about charge X? So let's dive into it. Oh, and I'm going to share the screen so we're all looking at the same thing. All right. Let me make that go up there. Okay. So my first stop is on page 3. Someone had suggested stipulations. I don't think we have any. I don't know that we're gonna have any. Ms. Reimer, if I take that out, you okay?
Yes, Your Honor, I typically include it just in case there are stipulations.
I'm all for the just in case approach. And Ms. Niles is operating in a little bit of a vacuum. She's listening and watching to the trial, listening to and watching the trial. She doesn't know what's yet to come or anything like that, or maybe she missed something. So she tends to err on the side of including it, but then she'll flag it for me. She's like, I don't know exactly where this fits. Ms. Wood, any need for the stipulations language?
Sure.
All right, it will come out. On page 5 is the language about defendant's choice not to testify. That will stay in there if Mr. Williams, you choose not to testify, and something on that in just a moment. If you do choose to testify, that will come out. So that's a conditional one. Mr. Williams, tomorrow, halfway through our session-ish, whenever the state rests, you and I on the record, in open court, but with the jury out of the room, we'll have a conversation about whether you're going to testify or not. Your lawyers will be right there with you, so if you have a question, you can ask them. But I do not ask Ms. Wood or Ms. Feely, is Mr. Williams going to testify? I ask you directly after I cover your rights that you have no need to testify if you don't want to, but if you do testify, you don't just get up and answer the softball questions from Ms. Wood. You're also subject to cross-examination. You can't take the 5th or something like that once you've committed to testifying, if you decide to do that. And all I'm doing right now is flagging for you that we will have that conversation when the state rests, and they're probably going to rest, I'm guessing 3-ish or something tomorrow. That will not be the time for you to tell me I need more time to think about it. You've had lots of months to think about it. You've been watching the trial. You certainly can keep talking with your lawyers about it. But tomorrow afternoon, once the state has rested, I have to, on the record, with the jurors out of the room, talk to you about that. Okay? All right. I heard you say yes. So for now, I'm leaving in defendant's choice not to testify, TBD. That gets us the statute of limitations. And let me tell you how I read the statute, which is 17.3.1. The statute says a rape can be prosecuted within 15 years of the commission of the crime. So really any hand-wringing about statute of limitations doesn't apply to count 1. I know there's language in the indictment about that, but 2014 wasn't 15 years ago. I don't think we need to engage in a statute of limitations discussion around rape. But I'm open to what we need to share with the jury, especially since a juror has already asked, is there a limit to when the state can bring these cases? The way kidnapping is charged, it is not a life sentence. It's a 10 to 20 because there's no bodily injury alleged in the indictment. It is an asportation kidnapping, which means it has to be brought within 4 years of the commission of the crime, and same with aggravated sodomy. We're many years past 4 years, past 2014. But subsection D of 17.3.1 says that a prosecution for rape, kidnapping, aggravated sodomy, all three of them are listed there, may be commenced at any time when DNA evidence is used to establish the identity of the accused. It doesn't mesh real smoothly with the rest of the statute that talks, or the subsequent statute that talks about when things are told and whatnot. The way I read D is if, and I think it applies here, if in 2018, Mr. Williams' identity is established as the accused in this case, the prosecution could be brought in 2098. Because that is any time after DNA has been used to establish the identity of the accused. And so I don't know that we need to engage in a whole lot with the jury. And I probably should have prefaced all this by saying, Ms. Wood, are you even going to raise a statute of limitations defense? Because if you are, then you need to push back against this D notion. The state has to prove it. There's no question they have the burden to prove that Mr. Williams' identity was unknown until DNA made it known. But once DNA made it known, the way I read the statute is there was no clock ticking. The state could have, they waited more than 4 years. This indictment was in 2024, so that's 6 years. So an argument could be made, I don't think it's a successful one, that ag sodomy and kidnapping are out because it was 6 years after the identity of the accused was known. In other words, the clock, the tolling ended, but that's not what D says.
So we're still fleshing this out with our appeals people, so if we could, I sent them the language, and so we may have an argument or a motion at some point.
Okay.
On the other, on not.
Count one, you agree DNA or not, it's on solid footing. It doesn't even run into the classical statute of limitations. It's not 15 years. That was close, but it's not quite there. But for the other two, I think it is statutory interpretation of D. Ms. Reimer, I'd like to hear from you on the statute of limitations.
Yes, Your Honor, I think the statute's clear that the prosecution can begin at any time when DNA evidence is used to establish identity.
It's exactly what it says.
Right, and also 17.3.2, which periods excluded, which is one of the, in this case, he was unknown. So therefore, any time that would have elapsed would be excluded anyway. So,
right, but if we use that one, that's where I started to wonder if just the defense was going to say, nah, given D, we're not going to push it. But under 3-2,
yes,
you agree that in 2018, Mr. Williams became known. He was no longer unknown.
correct. And then continue.
Okay, so if we didn't have D in 3-1, then you're out of luck with the ag sodomy and the kidnapping because the indictment was in 2024. And that's 6 years after he was known, which is 2 years more than 4 years.
Right, but D exists, which cures that.
Okay, so you're relying on D.
Yes, Your Honor.
And you really don't need to look at 17-3-2 because of D.
Yes.
Okay, because he could have been known. It really doesn't matter when he became known as long as it was through DNA work.
And that's for all, that's how we established his identity for all three crimes.
Yeah. Oh, agreed. No, I mean, the uncontroverted testimony so far is that Ms. Herring did not know the man who assaulted her. Right. She's identified him in court, but not as, oh, I know that guy, we were friends. It was Steve. So I don't think there's any evidence to contradict your claim, or put differently, there's evidence beyond a reasonable doubt that Mr. Williams's identity was not known until the DNA hit. But that was 2018, which gives the defense this little toehold of, but that was 6 years before the indictment. But I'm not ignoring D either. Okay. How much time does your crack appellate team need to come up with a contrary definition of the word any?
I think, I will probably just be able to email you and CC the state, whatever the answer is. I just think from a policy perspective, this is exactly what it was supposed to prevent these prosecutions years after he's a known person. And so I don't know that there's gonna be a lot of backing up sound,
Okay.
but I just, for the record, we do object, and may have a motion at the close of the state's case based on just the policy behind these.
Got it.
Laws.
And I encourage you to make that objection and make the record. It does seem to fly in the face of 17(3)(2) to have it then say, well, really, all those other exceptions don't matter anymore. But it's what the law appears to be right now. So I'll give you some time to look at that. Assume for a moment that D controls, then do I charge the jury at all on statute of limitations? And if I do, wouldn't it be different from what I put in here? I broke it out. You have 15 years for rape, 4 years for ag sodomy or kidnapping, and all this stuff about excluding. It really, wouldn't I say, it really doesn't matter what I'd word it differently than this, but it doesn't matter what the statute of limitations are for these three offenses. If identity is established by DNA, there is no time limit.
I think tracking the statute would be fine.
Okay.
If we would get there.
So I'll massage that and share something with you all. Maybe our emails will cross in the ether. Ms. Reimer, what kind of language were you thinking, if any, ought to be in the charge about statute of limitations?
I think that the pattern jury selection, pattern jury charges as you have it, and then reading D 3, 5, 2, 3, and 5 in the statute.
Okay. I'm going to do something like that. I don't think the pattern actually helps a ton. Because it was probably written, D actually is kind of old, but I'll adjust it to what the facts are in this case and then share it with everyone. And we'll see. So I'll come back to that. Next, states non-pattern 36 and 37. I'll take the easier one. 37, which is at the top of page 8, I believe is fully contained in the little paragraph that I just made gray on the screen. The point of 37 is made already in the pattern charge for rape. And so I'd be repeating myself and also getting kind of physiologically specific in a way that no witness has been that specific. So if you want to advocate for states non-pattern 37, now's the time.
Yes, Your Honor. I believe the doctor testified that there was bleeding which could have led to vaginal trauma. The argument has been that that bleeding wasn't from any trauma that occurred.
I'm talking about 37, not 36.
Oh, I'm sorry, Your Honor. Yeah, we did.
We can take it out. Okay, good. That was the easy one. I think that's the right answer. 36. Let's hear the argument for including. I wouldn't read it quite like that. That reads like something an appellate court would say, necessarily constituent elements. But I get the point that in particular, injury, you don't have to show injury to show that rape occurred. That's basically what this says. I think that is an accurate statement of the law. And it may well apply to the facts of this case. Why should that be in the charge?
I think based off of the testimony and the questions of the jurors about the injuries to Ms. Herring, I think it's important to include that it's not an element that we actually have to prove.
Okay. Ms. Feely, your thoughts about 36?
You object to the non-pattern 36, it minimizes the state's burden, makes, I mean, like, where would it end? Pointing out things the state doesn't approve.
Right. But what is your objection to me including a sentence like this? That's accurate. I mean, that's the law.
I still think just the pattern that says what the state does have to prove is what we would prefer.
Okay. All right, I'm probably gonna leave that sentence that I wrote in, but not give non-pattern 36. Any objection to that, Ms. Reimer?
Not at this time, Your Honor.
Okay, do you fear that it will suddenly become objectionable that I tell the jury that you don't have to prove an injury in order to find force?
Well, I would like to do some more research on 36 since you are not including it with the case law that's involved and why you would include it.
Okay, you're free to do that. And I know, Ms. Feely, you're objecting to including my distillation of state's non-pattern 36. It's always respectfully. Top of page 9, aggravated sexual battery. Included accidentally? Is this a lesser included? What's going on with that one?
It was an accident. Is lesser included? No, I'm sorry, it was an accident included, Your Honor.
Okay, so I can take it out.
Yeah, it was an actual
Okay.
yeah.
There were 2 different lack of consent charges submitted by the state, one tied to rape only and the other tied to the aggravated sodomy. And I have combined them into one. So if you'll read the charge in the middle of page 9, that I started with a little bit of gray highlight, that is an accurate statement of the law. And I think we only need to talk about lack of consent once, not twice. So give that a read, and then I'll start with the state's view. All right, Ms. Reimer, any issue with having just one lack of consent charge?
I just need a moment to review the 2 to make sure that
Okay.
they
When you're ready, say, here are my thoughts.
yes, sure. The state is okay with that, Your Honor.
Is
How
okay?
it reads, yes.
Okay. Ms. Feely, any issue with that?
The charge itself, but we would like for the named victim to be changed to alleged victim. I did a control F for the word victim and it's alleged in all the other ones, so just for consistency's sake and.
Okay. Stylistically, I changed it because the word alleged already is in that sentence. It just was a lot of alleged. But pardon me? No, I'll just put alleged in there. Because I read it out loud to the jury, I try to not make it as non-clunky as possible, but it will say alleged victim. That is how it is everywhere else. It's just then the verb alleged was used in that same sentence. Oh, put the word alleged in front of it for victim? Okay. I think they'll get the point, but I'll put that in. All right. That was it, except I put this little reminder at the end. I don't have anything in the charge. No one asked for it, and it's not necessary, I suppose, about the observation we shared in the hallway about there's not a limiting instruction for 413, but it is true that Mr. Williams is on trial only for the 3 charges in the indictment and not for anything else the evidence may have shown he was involved in. And so I'm wondering if I ought to give a charge that is more of a reminder. It doesn't limit it in any way, meaning it doesn't limit the jury's ability to apply the 413 evidence for propensity, character, evilness, whatever they're going to use it for, they can use it for. But probably they should be reminded that nonetheless, Mr. Williams is on trial for the Herring situation and not the Jones situation. And so I'm open to proposed language. I'm also fine crafting something or saying nothing at all if there is pushback to that. So let me start with the state. Ms. Reimer?
You're looking at the Georgia criminal pattern jury instructions. It says in there, when evidence is admitted under OCGA 224, 413, or 14, it would come in without the limiting instructions. And states that it may be considered for its bearing on any matter to which it is relevant. You also don't have to say anything at all.
Okay. Ms. Feely, that's helpful. I appreciate that. Ms. Feely?
I tend to agree, actually. I don't-
Just leave it alone and let the lawyers argue? I'm confident you'll say, whoever's giving the closing, hey, not only have they not proven their case in chief, but this other stuff, he's not on trial for that. I'm happy to say nothing if everyone is saying, please say nothing. And I heard Ms. Reimer say, please say nothing. What is Ms. Feely saying?
I say the same, and then if it yells at me, then I may have a different.
Okay.
Tomorrow, but I don't think they will.
All right, so I will hear back from you on the DNA exception, permanent tolling of the statute of limitations. And if you have a change of heart about some kind of language, just reminding the jury that Mr. Williams is on trial for the 3 counts of the indictment and not other things about which the jury may have heard. Okay, then I got through my areas of interest or concern. Ms. Reimer, were there things not in this charge that you thought would be there, or the reverse, something in there that you want out?
There's one thing that I did not actually include, but based on the testimony, it's a non-pattern instruction that about ejaculation after non-tolerant rape. Under Skipper v. State, I would ask that we include that language.
So if we look at the screen, this paragraph, which is part of the pattern, the recently redone good pattern that I believe makes your non-pattern 37 redundant. describes what carnal knowledge is, and it doesn't add something. I'm wondering how what you described is not exactly what Ms. Feely just said, which is jury charges don't say, hey, but it's not this, it's also not this, and it's not these 10 other things. Carnal knowledge is any penetration, period, not anything more than that. So I can read Skipper, but does Skipper say you have to charge it, or that it's not error to charge that?
It gives you the language, so I can pull up Skipper, and specifically.
You can tell me the citation.
It is 257 GA 802.
You said 802?
Yes.
So I say infliction of physical injury is not an element. We're covering that. What else, where it's a long opinion? Do you have a pin site?
Yes, it is at
Yeah,
804. I'm sorry.
Go ahead.
Yeah, 804. It's head under B. It's with the argument that the defense made and.
Oh, I see. Okay. Okay. All right. I'm gonna let you argue that to the jury. I don't need to validate it in the jury charge, since the jury charge sets forth the minimum. Anything beyond that would be penetration plus. So you are free to argue it. It's a correct statement of the law, but I won't include it in the pattern. Anything else?
I do not believe so, Your Honor.
All right. Ms. Feely, I know you've got your request into the appellate section, but anything else so far about inclusion or exclusion?
You know, everything I thought should be included is in there.
Okay. Then I will clean this up and send it back out with stuff removed that we said would be removed. I will change the statute of limitations charge to reflect the DNA provision subject to modification when we regroup. You all will have that as the close to final version. Ms. Reimer, is your sense that Dixon and Fowler and Whitmore will all be ready as of 1 o'clock tomorrow, as best you can control it?
As best as I can control it, Your Honor. I know the flight is due to land at 10:45 in the morning, so he will be here.
Okay. And then Ms. Fowler, is she gonna need to be wearing a mask, or what's her situation?
So I was able to speak with Miss Fowler today. She's feeling better.
Okay.
But I believe that she said she was going to wear a mask.
Okay.
That was if she came in today. I'm gonna talk to her again tonight and see if she's gonna be wearing a mask or not, but
Okay.
she is doing a little better.
Good. Glad to hear that. And then Ms. Whitmore, was she already scheduled to be here tomorrow, or?
Yes.
Good. All right. So she'll be here. All right. Anything else from the state?
No, Your Honor.
Ms. Wood, anything from the defense?
No, Judge.
All right. Well, thank you all. Be here a little before 1, please, and we'll try to start as close to 1 as we can. Appreciate it.
Thank you.
Oh, tomorrow after they rest.
Okay.
Yep.